thought we were missing one more, weren't we?
Yeah, and what about this one? This is how. Oh, well. We already have it.
We are here. It's 4 o'clock. 4 o'clock cell time.
Yeah.
Fewer that show up, the better, huh?
This way you have a microphone. All right, Dave, I'll get over here. Yes. I'm doing good. Just come back on vacation in May. A little bit. Well, most eastern pointed just in front of it. We That's all lined up. We did go out on that.
Well, I was in San Diego, but I wasn't even really outside of it. Yeah. My arm out the window, his arm's brown.
Brother actually in Stein, he just has a small house. Not exactly.
Do it.
If you come back, if they're not going to claim it. Yeah, I got to make sure. I think we're ready if you are. We have a quorum.
Okay, we have a quorum, and we'll bring the agenda for July 15, 2014. Number 1, approval of summary minutes of July 1st, 2014 regular meeting. I would entertain a motion of approval.
Mr. Chairman, I move we approve the minutes as stated.
Second.
I have a motion and a second. Any other discussion? Hearing none, all in favor indicate by saying aye.
Aye.
Same sign opposed. Minutes pass.
Mr. Chairman, I've got an idea here because we didn't know what kind of turnout we would have. We've got multiple public hearing items, but not a great deal of turnout in terms of public comment, except we do have one item on your agenda that has a real live applicant, and that is item 5 there on the street name change, and Mr. Lund is here, and it would be within the commission's discretion. We put these on the agenda in the order in which they came in, were filed and discussed, and that was the last one in. But if you would so desire, you could move item 5 to the top of your public hearing agenda and address that item, and then that would allow Mr. Lund to address that and be on his way.
Any of the fellow commissioners have any concerns or problems with moving item 5 up on the agenda?
Do it. Do it.
Hearing none, we will move public hearing item number 5 as the first being heard, which is application M14-16 filed by Eric Lund on behalf of, I messed that up, Virus? Close enough. Okay. Virus Technologies requested and changed official street name located in the airport industrial area. At this time, we'll hear from city staff first, I believe.
Thank you, Mr. Chairman. You have in front of you an application for street name change, and the subject area is out in the Airport Industrial Center, where earlier this year we had a replat of that area, a reconfiguration down at the west end of this street. And as we reported to you, the way that streets names get established in the city of Salina is that a plat of a subdivision comes in front of you and the developer or owner proposes street names on that plat, and staff reviews those to make sure that they're not a duplicate or sound or spelled the same as other names. Planning Commission has the discretion to approve or disapprove those names. Once that plat is approved and becomes recorded, that becomes the official street name for that street, and then it's used for addresses for water service, gas, electric service, 911 response, mail delivery, all those things. And of course, the city goes out and posts a sign at the intersection identifying those street names. We also have a process for changing street names, and that's what you have in front of you today. We have had cases where a subdivision developer initiated a change. We have had a situation where all the residents of a particular short street petitioned for a name change, and we've had a case where we discovered a name that had been approved was confusing with another name in the community, and it got changed for public safety reasons. Where we're at today is a street that was originally named Works Street on the original plat of the Airport Industrial Center after a former employee of the Airport Authority. And then in 2005, when the Salina Vortex project was proposed, there was a request made to change the name of Wirtz Avenue to Vortex Avenue. So starting at this intersection with Centennial all the way to the cul-de-sac, the name was changed to Vortex Avenue, and that changed officially in 2005. That was recorded in the deeds office. New street signs were placed, and the address for Salina Vortex is 1725 Vortex Avenue. Over at this location right here, under construction now, is a new building for Veris Technologies. They are currently sharing space in the Geoprobe Systems campus up on North Broadway. They have purchased an 8.5 acre lot at the west end of Vortex Avenue from the Airport Authority and have a building underway. We issued a permit for that under the name of, or the address of 1925 Vortex Avenue. And Mr. Lund and Veris have submitted this request to change the name of the dead-end segment here, starting at Scanlon to the terminus there, to rename that to Clay Ridge Court. And they feel that their business and their future businesses that may locate west of Scanlon Avenue have no association with the Vortex name. We have looked at that. We have found that there are no similar sounding or similarly spelled names. There's no names in the city and the county for a street that begin with the term Clay. So there should not be any confusion or public safety concern about that. It's not particularly ideal to break streets like this up into segments, but it's not unprecedented. If you're driving on Ellsworth Avenue east of Ohio and you get to Courtney, as soon as you go east of Courtney, you're on Eastgate Drive, not Ellsworth Avenue. The same with Bradshaw Drive. So we have breaks in segments like that, and this is identifiable segment from here to here. Of course, one of the reasons we have a public hearing and we get notice out is there are other owners that are potentially affected. The Airport Authority owns the rest of that property on that street. I contacted them and they are supportive of the street name request. I also contacted Salina Vortex and they had no concerns about changing this particular stretch because it did not affect their address or their street name. The FedEx facility is addressed off of Scanlon, and that is not going to change. So really the only affected parties are Veris Technologies and the fact that any future Airport Authority development would be on a street named Clay Ridge Court instead of Vortex Avenue. The other thing that Mr. Lund pointed out and correctly is when we use the the suffix avenue, that usually implies a through street or a street that runs for an extended length, and this is not really an avenue, and so that's why the suffix of court, usually it's court or place or circle, is used for a street that ends in a cul-de-sac. So if you receive no objections to this requested public street name change and you are supportive of the Veris request, then you should by motion recommend to the City Commission that a resolution be approved that would officially change the name of Vortex Avenue to Clay Ridge Court west of Scanlon Avenue, with the piece east of Scanlon Avenue remaining Vortex Avenue. So with that, I would be open to any questions that you have, and we'd also want to hear from Mr. Lund.
Any questions for staff? Eric?
Yeah, I think I do. What do you anticipate the cost are to the city to do this?
The cost to the city would be the production of a letter that we send out to about 17 entities informing them of the street name, and then the cost of taking Vortex Avenue sign off and replacing it with Clay Ridge Court.
And what about city maps and so on and so on?
Well, those are updated periodically. Our GIS supervisor maintains the official street map for the city, and it is not completely unusual to change a street name. So yes, there will be some maps out there that are obsolete, but there's still some maps floating around out there that show this is Wirtz Avenue. So the important thing is that the resolution that changes this will get recorded, that all the entities, which would involve 911 response, would involve utility providers, the postal service, all of those would get notified of the street name change, and that's what happens. But basically, a resolution gets drafted, it is recorded in the deeds office, and that essentially amends the platted name on the street.
Can we hear from the applicant at this time?
Do you have any questions? You just want me to speak?
You may want to state your name and address for the record. That would help out her.
Eric Lund, and our current company address is 601 North Broadway, Salina, Kansas. I think Mr. Andrew described this pretty accurately, why we want it changed. There's possible confusion. Just having our building that close to a major facility like Vortex that's got the same name. We could see people getting off interstate, heading west on Waterwell looking for Veris, and they see Vortex and drive into Vortex, think, well, Veris must be in here somewhere because here's Vortex, and drive around for a while, and then finally go into the receptionist and say, where's Veris? It's, here's Vortex. And they go, no, Vortex Avenue is over here. It just seems like there could be a lot of confusion for us and anyone else that locates over here to be confused with Vortex. So,
Okay. Any questions for the applicant? Thank you for your time. I will open up to anybody else in the public who'd like to comment on this issue. Seeing none, I'll bring it back to the commission for discussion and possible action or motion.
Mr. Chairman, I've on a personal quest to ride my bike on every city street, and one of the things I've discovered is that we have a lot of one-block, two-block streets. I've looked at the list of all of our streets and say, in Topeka, the list of all the streets, we have almost as many street names as Topeka does, even though we're barely a third the size. So it's just kind of a strange deal to keep naming short streets, in that it makes the city more complicated, and maybe it makes the city look bigger to some statisticians. But it's also an interesting precedent. I own all the frontage of one block. Can I apply to have that block renamed to some family name that I like? I don't know. At any rate, that being said, I have no real objection to it. It just seems like it's adding to the artificial aggrandizement of the city.
Any other comments?
I don't disagree. I want to make a comment. I don't disagree with what happened in City. I think the town's a bit confusing in the way the streets are named anyway. I found that when I came here, they're named after anybody that wants their name on a street, seems they can get it on a street somehow, I guess. And you go to communities like, I like communities like Oklahoma City, where everything's numbered, avenue and street, and it's easy to find where you're going in a community like that. Southeast, northeast, northwest, southwest, they all mean something. Here, a street name, you've got to get a map out to find it. So it's too late to change it, I understand, the city's name, but I just wanted to mention that, and this is not going to help the situation, but I don't think there's anybody against it. I'm not necessarily against it either.
Any other comments?
Oh, yes, but now we have Google Maps, so who worries?
Deal anymore.
Yeah, right.
Yeah.
Right.
How soon
Vortex
will
have a
Google
problem
know?
with naming the whole street?
Quicker
What's
than
that?
the city.
Would Vortex have a problem with just renaming the whole street?
Yes,
Seems like a big.
Yeah.
since they were the instigators of being located on Vortex Avenue, they didn't have a problem with the segment, dead-end segment from Scanlon West being Clay Ridge Court, but that should not be construed to think that they would want the other street renamed, since they went to the effort of changing it from Wertz to Vortex.
And is Vortex's address actually Vortex at 2270 Vortex Avenue?
Their address is 1725 Vortex Avenue.
Even though their front door faces Centennial Road?
Well, the main driveway
Wouldn't matter.
that you get there from is off of Vortex Avenue, so that they don't have access to Centennial Road or Waterwell at this time, and so Vortex Avenue was the means by which trucks and customers and everybody get to that location. So that is why it has a 1725 Vortex Avenue name. Mr. Lund didn't have any choice. Their address was assigned at 1925 Vortex Avenue, and if this request is approved, their new address will be 1925 Clay Ridge Court.
Any other comments?
I'll make a motion.
I'd love to hear a motion if you do.
Make a motion that we approve application M14-16 as presented.
Second.
I have a motion and a second. Any other discussion? Hearing none, all in favor indicate by saying aye. Aye. Same sign opposed. Motion passes. Thank you. You want to go back to number one, or would you like to?
Who seconded that motion?
Mr. Boxam.
Mr. Box.
Shall we go to one, or would you like, two, or,
Yeah, I think we just go back to the regular order.
okay. So we'll go back to the regular order of the public hearing, which would be action item number 2 on your agenda. Application Z13-9 filed by the Salina City Planning Commission, requesting amendment of the surfacing requirements for off-street parking for the driving areas. And will we hear the report from you, Dean?
Thank you, Mr. Chairman. Just wanted to remind the commission that on items 2, 3, and 4 upcoming here, you are wearing your legislative hats, not your quasi-judicial hats, so you are free to discuss, debate the merits back and forth, and your need to provide specific findings are not as high as they are for when you're acting on an individual piece of property. Your general rule is that your decision should be based on what you think is in the best public interest for the community. And so all 3 of these are text amendments. All 3 of these deal with what you think is in the best interest of the community of Salina. And our first item here deals with parking lot surfacing. And what we've indicated is basically the ordinance we have in place is unchanged since 1990. And with the adoption of the new comprehensive plan, and with some of the goals in the plan in terms of upgrading development standards in our industrial areas in the city, one of the things we did with you was we did a comprehensive review of the surfacing requirements for driveways and parking lots in other Kansas communities. We found that we were somewhat out of step in terms of the exemptions that we allow for gravel surfacing, And John, if you could go to those exemptions right now, which is that attachment 1. This is the way that our ordinance is currently structured. And so just to walk you through this today, absent some covenants from a developer, if somebody wanted to build a new house in Quail Meadows Estates off of Schilling Road, and they said, I'm going to build a new house and I want my driveway to be gravel, they could go out today and build a gravel driveway. Their approach in the right-of-way would have to be paved, but anything that was on their own property could be gravel. And if I was out building a duplex or a triplex in a new area or an established area, I could have gravel parking as long as my parking area didn't exceed 6 spaces. And we have some areas in the city today that are zoned agricultural, and if they have parking areas in agricultural zones, they don't have to be paved. And then in all of our I-2 and I-3 zoned areas, paving is optional. It's not required. So you could go out and build a new warehouse or manufacturing facility and have gravel parking today. If you have multifamily housing, if you have a school, a church, parks and recreation facilities, and you've got a lot with more than 6 spaces, you've got to have paved parking. We also have an I-1 industrial park zone that requires paving. We don't have many I-1 zoned areas in the community. The other thing that occurred was the City Commission, when they enacted the current ordinance, stated that if you have a gravel parking lot and you were in existence on December 17th, 1990, you can maintain that gravel parking lot. So the Little Red Barn at the corner of Ash and Ohio in December of 1990 had a gravel parking lot, and today they still have a gravel parking lot because it was grandfathered in and they haven't done anything that would trigger a requirement for it to be paved. Today, if you had a change in use of a building that required an increase in the number of off-street parking spaces, the new or expanded area must be paved. And if you do a building addition and you've got gravel parking, but your addition results in additional parking demand, then the new or expanded area. But we don't have anything that results in going back and retrofitting a parking lot. So if you've got a grandfathered parking lot, there's almost no event that would trigger you going back and paving that. So what we started out with talking to you about those exemptions, about the grandfathering, about having some triggers that might result in paving of existing gravel parking to upgrade those. And we pointed out to you that drafting a text amendment was a starting point, and that this is supposed to be a public legislative process with public input. The City Commission's going to ultimately decide the question, but they should do so based on your input and input from business and property owners. So you had a public hearing on this question on October 1st, 2013. There were some who attended that hearing and expressed concern that the text amendment drafted by staff on behalf of the Planning Commission might have the unintended effect of requiring areas like storage areas or equipment storage areas or staging areas to be paved if the ordinance was not clearly worded enough. And so at the end of that hearing, you didn't take any formal action, but you recommended or directed that a committee be formed made up of property owners and business representatives, and their particular focus was more so on the I-2 and I-3 areas. And so earlier this year, you appointed Tim Rogers, James Hall, Jeff Montgomery, representatives from McShares, Inc., Jeff Mays with Compro Realty, and Dennis Laver from the Chamber, as well as Mr. Boxa, Kennedy, and Story from the Planning Commission. That committee met multiple times. Staff laid out issues and options at their July 1st meeting. That committee reached a consensus, and their consensus was that the parking should continue to be, or the paving should be optional in that I-2 or I-3 district. So John, if you could go to item 6, which is a summary of their recommendation. You've got it as slide 6 anyway. I think it's the last one there, summary of. So on July 1st, the committee met for an hour and a half and discussed different options. Basically, their stated recommendation to you was to retain the current paving exemption for I-2 and I-3 zone property, and they said if there were aesthetic concerns that those should be addressed through the adoption of gateway and overlay districts such as the North Ohio Gateway Overlay District. So the committee was given that information. You have been given that information in your packet. Today we have a North Ohio Gateway Overlay District. There's property in that district that's zoned I-2 and I-3. That overlay district requires paving in the overlay, even though I-2 and I-3 make it optional. The same thing in the Northeast Industrial Park, which was an urban renewal area. There were covenants that required all parking to be paved, even though most of the property was zoned I-2. Basically, the position of the committee was that they wanted to retain the ability of businesses to make a financial decision as to parking lot surfacing in the city's industrial areas. They did not take a formal position on the triggers that might require a pre-existing gravel parking lot to be paved. So where we are today is our hope is that we'll walk through this issue, that you will make a recommendation to the City Commission as to the appropriate amendment, and that will be then taken up by the City Commission. So John, if you could go to the number 4, which is the original draft amendment. And so the original amendment that was prepared for you and originally discussed on October 1st, 2013, had a general requirement that all off-street parking spaces be paved with asphalt or concrete. The alternative language there that for grass pavers or brick pavers or other alternatives or porous concrete, that is not a change. And then since we don't have an adoption date, that date would clearly change to 2014. But basically it would again state that whenever a change would occur, if I own property and I have a gravel parking lot, and it's in existence on that date, it is grandfathered in. And then the two things that could change that status is I have a renovation or reconstruction or expansion that is equal or exceeds 50% of the appraised value of the existing improvements, or I do an addition that results in more than a 30% increase in floor area. So I will pick on the insurance office, formerly Knowles Country Real Estate at the corner of Ash and Ohio. If they did a project there that increased the value of that property by more than 50%, that would require them to go back and pave their gravel lot. If they did an addition to that building that was more than 30% of the floor area of the existing building, they would have to go back and pave their gravel lot. Again, that is what the proposal is. The original proposal, the only exception that was in there was for single-family and two-family dwellings located on a gravel street or coming off a gravel alley. So John, if you could go to slide 5. These are things that we wanted to point out to the commission are available, and they're certainly not the only ones available. You've got the draft in front of you, and these are things that could be built in or added to the text amendment. One thing the text amendment does not address is vehicle display areas. So if you're Conklin Cars or you're Ron MacArthur Ford, your vehicle display areas are required to be paved with asphalt or concrete. That determination was made by a written administrative interpretation of the zoning administrator and has been in place since around 1990. The same thing with areas in commercial districts that are used for storage of equipment or service vehicles. You could have a contractor's storage yard or contractor's office in a commercial zone, and if they had a fenced-in area where they stored equipment, that could be surfaced with gravel or asphalt millings. That is allowed by administrative interpretation today, but could be added to the ordinance. As the parking lot surfacing committee discussed a couple things that might make the businesses feel better or better protected, to clarify that like product staging areas or outdoor storage areas could be surfaced with crushed rock, gravel, or asphalt millings. There are different options there. And then one thing that was discussed was requiring paved parking if that parking was in the front yard setback area, and exempting it in industrial areas if it was located behind the building. So that is an option that's available. It's kind of an in-between. But instead of exempting I-2 and I-3, if you were in the front yard parking, that would have to be paved. If you had rear parking, that would not have to be paved. And then if you could get to the last there, John. We have had almost all the focus with the committee and discussions about economic and industrial development and the impact of asphalt and concrete paving. As a staff, one of the things that we're most concerned about is today, if I want to go out and I have a single wide driveway and I want to put a little wing on it to park a boat or a trailer or camper, today I can put down crushed rock or gravel under this ordinance as it's proposed. Anything that I put down in the way of a driveway or parking pad would have to be paved with asphalt or concrete. So this last provision, the ordinance could be modified to have a provision that says if you want to put a parking pad down next to your driveway for a boat or camper or RV, that could be on crushed rock, gravel, asphalt millings, or other all-weather material. So those are some things to think about. And then, John, if you could go to slide 6. That is the summary, or the draft amendment for the committee version. You've got it down here, slide 6. This is intended to convey the recommendation of the parking lot surfacing committee that looked at this. And keep scrolling, John. The difference between the original draft that you considered in October and this version is this version reflects what the recommendation was of the parking lot surfacing committee. was that the paved surfacing requirement would not apply to single and two-family dwellings with driveway access on unpaved streets and alleys, or to property located in the I-2 and I-3 zoning districts. So if the committee's recommendation became your recommendation, that is essentially what it would look like. I wanted to get into some physical layouts, and John, could you put up the El Dorado bus aerial photo? I think the parking lot service committee has this site completely memorized because we looked at this every meeting and discussed it at every meeting, but I thought I would walk the planning commission through this. We just discussed Salina Vortex, which is down here in that location. This is El Dorado Bus, which is addressed off Wall Street, and they have their parking on the Wall Street side, and on the side their parking for employees and customers is paved. It is paved because either through an agreement, covenant, or arrangement with the Salina Airport Authority that resulted in a requirement for that being paved not by the city zoning ordinance but by the Salina Airport Authority. And then this area here is all gravel and asphalt millings, and that's a staging area and storage area, and so that is not required to be paved. And even under the original text amendment, it was not an intent that that area would have to be paved, only the parking area used daily by customers and employees. So the primary difference between the two versions is under the original draft text amendment, these parking spaces would have to be paved with asphalt or concrete because the city zoning ordinance required it, and if you accepted the recommendation of the surfacing committee, then the discretion to pave or not pave would still be with the business or with their arrangement with the airport authority. And John, if you could put up the I-2, I-3 zoning map. This is kind of hard to read, but one of the things that the committee looked at is said, well, if we exempt out I-2 and I-3, what geographic areas are we exempting out of paving? And so our I-2 and I-3 areas are concentrated north of downtown and parallel to the railroad tracks. There's a couple areas out here where Blue Beacon and Graves Trucking were located, and then obviously you have the airport industrial area, which has a high concentration of industrial zoning. So when you're looking at the geographic areas of where paving would be required or not required, those are the areas. And then, John, if you could show us the aerial photo of Chuck's Bar. This is a property. It is on North Santa Fe, north of downtown. It is zoned I-2, light industrial, but it's today Chuck's Bar, and there's a proposal to do a demolition and a substantial expansion and renovation of that property. Today, because it's zoned I-2, any new parking required or associated with this would be allowed to be gravel or asphalt millings. It would not be required to be paved. And that's one of the things that staff wanted to point out, is that just because an area has I-2 zoning doesn't mean that necessarily all the uses or users in there are industrial or manufacturing. We have areas, particularly north of downtown, that have commercial buildings or businesses, and when you're deciding pavement surfacing requirements based on zoning, it doesn't mean that you're just exempting industrial uses, you're also potentially exempting commercial uses. So if the original text amendment was approved as prepared, any expanded parking for these changes here would have to be paved with asphalt or concrete. Under the current ordinance and under the recommendation from the Parking Lot Surfacing Committee, any expanded or new parking areas constructed could continue to be gravel or asphalt millings. And I think our final example that we discussed, John, is the Bulk Solids Research Center. And that is located right here. This is where Catron, formerly Premier Pneumatics, was. If you drive through this area, which is the Northeast Industrial Park, and you drive by, you will see that this parking lot, the former Rima Bakeware parking lot here, they're all paved with asphalt and concrete. And the reason is, even though they're zoned I-2, the Northeast Industrial Park, as an overlay district, required paved parking, either asphalt or concrete. So that brings us to your options. And the following receipt of any public input you might get. One option would be to approve the proposed parking lot surfacing text amendment as originally drafted and presented. This would eliminate all current paving exceptions, but it would apply prospectively and not retroactively. You could approve that text amendment with any additions to or modifications that a majority of you are supportive of. That would include the modification recommended by the Parking Lot Surfacing Committee. You could continue the public hearing on this item to allow for additional public input. You could refer this back to staff for additional study, or you could recommend that no changes be made at all. I think option 2 there, which is the text amendment as drafted with any of those options for modification, such as including the I-2, I-3 exception back in, or clarifying things about storage areas or vehicle display. And we would particularly want input on the residential side on being able to put a wing or pad on your driveway, because again, the committee that looked at this focused on the economic industrial development impact, but in terms of properties impacted, the ability today to put a gravel wing on your driveway and the ability tomorrow to not be able to put a gravel wing on your driveway is probably something you would want to think most about. So I've tried my best to give you the history and lay out the discussion that has taken place, but this started out with the goal of trying to upgrade our development standards in industrial areas, and that was the primary focus for bringing it forward. And at this point, we'd be open to any questions from commissioners, and then following that, any public input.
I'd open up for any questions to city staff from commissioners.
Todd, I don't specifically have a question, but if you will, I sort of got confused on page 20 of 69 when I was reading this particular component of our packet, and I wrote down specifically what I thought we agreed to at the meeting, the Parking Surface Committee meeting. And it was pretty succinct and pretty simple. And if you will, I'd like to read what I wrote down. Somehow I'm not sure this is what got incorporated.
Okay.
And then Jerry was there, so was Wally, Dennis was out there, and they were all there. So when we went through this, I wrote these down specifically. They may be in there, but I'm not real sure they're stated that way. So, having a simple mind, I have to keep things pretty simple, So what I think we agreed to at the committee meeting, and correct me guys because I could well be wrong, is number one is I-zoning would not have a paving requirement, period. except if overlay districts were established which scheduled those to be paved, which is, I think, in agreement with what Dean said. Number 2 was C zoning would be required to be paved. Commercial zoning would be required to be paved. That would include parking lots for cars and all those things if they're C zoned, not I zoned, but C zoned. C zone would require paving. Then number 3 was R zoning, residential, all new development or redevelopment must be paved. Exception being if the development or redevelopment is on a street that is not paved. Then it would not require paving because it's not on a street that's paved. That's what I thought we agreed to. Is that what's said in here?
This is our translation of what you just said, and the part that's left out is in commercial districts, the C districts, because paving in C districts has been required since 1990 and is not up for discussion or proposed to change. And so the discussion in terms of an amendment has no effect on commercial districts because they have always required paving. So essentially this up there states that the current paving exemptions in residential zoning districts would be eliminated except for the exception for driveways and parking areas on gravel streets and alleys.
And then C was not included in what you summarized simply because it's no change
It's
from
not a
current zoning.
change from the status quo.
Then I just want
then-
to clarify.
And then the committee recommended that the current paving exemption for I-2 and I-3 remain in place, and to address the aesthetic or appearance concerns, perhaps about gravel lots, was that gateway or overlay districts would be used in those sensitive areas to address the paving requirement.
And that's consistent with what I said.
Sorry, I don't mean to hog, it sounds like the study commission's hogging the time here, but when we talk about overlay districts, those are already determined, are they not?
Well, we've had plenty of discussion about gateways.
Okay, the
And
gateways.
there's about 9 identified gateways into the community that the Planning Commission has agreed are gateways, and those would be primarily our interstate entrances. But Ohio Street from I-70, 9th Street from I-70, West Crawford, Magnolia, Schilling, Waterwell, those would be considered gateways into the city from the exterior. And then we already today have a South 9th Street overlay district, and in 2006 a North Ohio Gateway overlay district was adopted, and that requires paving. All the property that's around the galvanizing plant up there on North Ohio is zoned industrial. However, that's right next to Ohio. It's in an overlay district, so the idea there was, although I-2 doesn't require paving, the overlay district would, because it's on a gateway into the community.
So this particular ordinance isn't going to require us, though, to enumerate all of those various
No.
gateways.
What essentially says is, and we have identified our cons or negatives about gravel parking that have been identified is there's difficulty with snow removal and pavement marking. You get ruts and sinkholes, dust and dirt, you get rock spread and spill, and then that general category that some people perceive gravel parking lots as unattractive. So the approach that the committee took was leave it as is, but if there are sensitive areas or gateway areas where appearance is of concern, then we would be, as a staff, following up with the Planning Commission and the community to say, do you want an overlay district for North 9th, or do you want an overlay district for West Crawford, or do you want an overlay district for Waterwell Road, those type of things. And then what the committee's saying is address it on a gateway basis or overlay corridor basis. You could have a North Santa Fe overlay district and have different standards for North Santa Fe than you do for other streets. So what the committee's, we don't have all the tools in place now, but what the committee was basically saying is if you have a corridor or a gateway that you're concerned about, address it through an overlay district.
And I guess what I was looking at, I know we may not be able to enumerate them because I don't know what the next exit for Salina is going to be called, and it may be it may be a gateway also. But what I'm wanting to come up with is if something like that were to occur, that somebody who isn't familiar with this ordinance, somebody who's coming to town, or somebody who wants to open a business, could look at it and say, this particular area, if I open a business that's an industrial in nature, will require pavement. Not after the fact, so they come and find out, oh, now somebody's thrown a roadblock up.
Well, I will give you an example. It has not come to fruition, despite all work and efforts by city staff and our city attorneys, but we had an area that was identified as potentially surplus city property related to the acquisition of right-of-way for the North Ohio overpass, and it was right next to, directly east of, Midway Wholesale, which is near the corner of York and North Ohio. And they were interested in acquiring some of that property from the city. And so we had a meeting with their representatives, and they met with the city's development review team. And whenever we have a development review team meeting, first on the agenda is planning and zoning. So the first thing we said was, first thing you need to know is that you are in the North Ohio Gateway Overlay area. Here's the map, and any paving or any parking that you construct will have to be paved. And so that becomes the mechanism for letting people know.
Okay.
But the way it stands right now, if anybody wants to come into an I-zone district, regardless of where it's at, if it's not in an overlay district, they would not have to pave it.
Correct.
They would have to come before us and get permission to not pave it. They just simply wouldn't have to pave it. Isn't that correct?
That is correct.
Okay,
John, do you want to go back?
That includes gateways such as maybe Waterwell Road. I don't know what that's zoned out there, but that means somebody could build as a corner of Waterwell Road and 35, which we had that incident, and not pave if that's zoned I right now. Yeah, I don't know if you'd have to.
Yeah, I'll go back to this illustration. Again, this is Chuck's Bar north of the downtown. What the committee basically said was we would recommend that the I-2, I-3 exemption remain in place, and if there are areas of concern or corridors of concern about gravel parking lots, then it would be incumbent on staff to bring to you and you to decide, do we want to create a North Santa Fe overlay district north of downtown? And if you were sold on the concept of creating an overlay district for North Santa Fe, then through that North Santa Fe overlay district, any new parking lots or parking areas would have to be paved. But if you followed the original draft that closed all the exceptions, then if that got adopted, then any new parking constructed here would have to be paved with asphalt or concrete. That would apply to I-2 and I-3 across the board. If you adopted the recommendation of the surfacing committee, then absent a overlay district or special district for North Santa Fe, then this could be gravel, and the way that it would become required to be paved is by having an overlay district. And the only place we have that in place today is North Ohio, because staff identified that a lot of the property abutting North Ohio, and we pointed this out to the committee, where Casey's General Store is located at North and Ohio Street, Casey's General Store is zoned I-3 heavy industrial. So it is a commercial business. It has all the commercial characteristics of Iron and Ohio, but it happens to be zoned industrial. And the paving and landscaping and everything that's there was done voluntarily by Casey's, not because our ordinance required it.
I'd like to move forward to public comments if we may. I will open it up at this time for public hearing. If anybody has any concerns under this application, please come forward, state your name and address for the record, please. Seeing none, I'll bring it back to the commission for action or additional discussion. The only quick question that I have, if there's a quick response to this, would be if somebody comes in and has a $100,000 appraised building today, and they're planning an addition, and they meet with the DRT, at what time does the county appraiser determine whether they're at 50% over the appraised value before they move forward?
You want to explain to Mr. Welsh what you just did with Save a Lot, Dustin?
Sure. What we would do in that scenario is we would take the estimated improvements that would be estimated by the contracting work that's being proposed as part of that addition or renovation, and we would compare that to the current county appraised value of the building. So what we do in that instance is we would get with the county appraiser's office or look up the current valuation for tax purposes of the building and then compare that to whatever the renovation value is. And if that exceeds 50%, then we would consider it a substantial improvement, and that would be the trigger for any new regulations or meeting the current regulations. Did that answer your question?
Sure.
The example I gave earlier was that there used to be an SRS office building and other uses there at the corner of Belmont and Magnolia. That property was purchased by Bennington State Bank, and they didn't change the actual footprint of the building, but they made renovations to it that were about double and a half the valuation of the current building. So our landscaping regulations, the front yard landscaping requirements, don't come into play on existing properties unless you have a substantial improvement. And so as part of their renovation of the building, they had to incorporate front yard landscaping into their project. And so when we explained that to the Planning Commission, they thought that was a reasonable benchmark to use for a substantial improvement that might result in gravel being converted to paving.
Okay. Chairman would...
Todd, I'd make a motion.
Motion.
Serving on this commission as well as the committee appointed, I would make a motion that application Z13-9 be recommended for consideration to the City Commission based on what is consistent with the parking lot subcommittee's recommendation.
Looking
Which
for a
are
second.
those 4 items that I mentioned, which are clearly
second
stated.
I have a motion and a second. Any other discussion before?
Yeah, I'd like to make a couple real quick before we do. First of all, I'd like to thank Mr. Andrews and the study committee. Met at 2:30, several days, hammering through this, and sometimes we didn't all agree, but it was neat that people kept coming back for more, and I think this is a good start. And it kind of scratches everybody's itch a little bit. One of the things that kept coming up in that committee that I want to put a kind of a flag on is that looks are important. I mean, there was a discussion that we've had all the time about, well, are we just talking about something that makes something look nice? And the answer is yes. I think, as we live in this city, and as people come to this city, there's an expectation that at least in some areas, be they overlay, gateway, whatever the terminology is, that they look attractive. And so I think this begins to do that, and so I'm going to support this.
Thanks for your comments. I have a motion and a second. Any additional comments? None. Hearing none, all in favor indicate by saying aye.
Aye.
Opposed, same sign. Motion passes.
And I do want to thank Mr. Story, Mr. Box, and Mr. Kennedy, and all the members of the Parking Lot Surfacing Committee for taking time out to look at that issue more closely and and advise the Planning Commission.
Moving on to agenda item number 3, application Z14-4, filed by the Salina City Planning Commission. Requesting an amendment to sections 42-168-01, adding a definition for electronic cigarettes.
Mr. Stack has reminded me that the only members of the public we have here are for item that comes after this. And so, since I guess we have Mr. Pruitt here to discuss item 3, but it would be again within the discretion of the commission if you want to move item 4 ahead. We have some members of the public here that would like to speak to that item. So if you wanted to, you could move item 4 ahead of item 3 to allow those in attendance to be able to participate in that discussion.
No problem with that.
Go
I'll
ahead.
take a poll here.
It's fine.
Okay.
Okay, commission seems to be okay.
So we will open the discussion of item 4, which is something that you authorized at your meeting on June 17th, and we discussed the issue with you. I think you are pretty familiar with the concept of wireless communication facilities and what we do on private property. And essentially, the process that we have for private property is when you have a co-location or a relatively simple placement or a tower that's going to be located in an industrial or obscure location, then those are handled administratively. If you're trying to put a tower up in areas that are more sensitive from a neighborhood or appearance standpoint, then we get into a public notification and hearing approach. We have been approached about the idea of initiating a distributed antenna system or a more closely spaced system of antenna nodes. And the primary difference here is that the focus is on placing those antennas and that equipment within the public rights-of-way in the city of Salina. And that is not something that's presently accommodated or allowed for under our current ordinances. And so the primary difference of what we're seeing here is that the DAS concept, the facilities or the network is denser, the antenna sites are closer together, we're talking about lower heights, and we're talking about wanting to locate on utility poles and light poles in the public right-of-way. And our ordinances in 42-69 is set up entirely for private property. And so we summarized for you some of the issues with that in terms of what zoning for private property versus right-of-way, making sure we have a level playing field, what federal preemption there is, that we can't simply take action that would prohibit or have the effect of prohibiting the provision of personal wireless services. An important thing we can't do is say we like Google fiber, but we don't like anybody else's fiber. We have to treat everyone in a non-discriminatory manner. And so the text amendment that's in your packet and that we have put forward for your consideration today deals with placement in the city right-of-way, and some of the elements it deals with are pole height, the maximum antenna height, the maximum pole circumference, the maximum dimensions of pole-mounted equipment structures, the aesthetic standards, in other words, dealing with colors and materials, and then the screening and camouflaging of the antennas. And two of the most important parts are use of replacement poles and also in our current ordinance for private installations, we have a kind of a sliding scale of locational preferences, and the least preferred areas would be like our residential historic districts. So this does make some distinction between residential districts and our C4 districts. One thing that the text amendment does not do is this amendment does not address ground-mounted equipment structures, and it does not address antenna hub buildings. But John, we may want to go to some of the visual illustrations, just show we can walk through that before we focus on the text. It wouldn't be that one. But this is, if you could go back one, John. Could you go back to whatever the first slide is? Okay, this gives you an overview of how the system would work, and so you would have antennas placed on poles at various intervals, and most of those poles would be in the public right-of-way, and many of those poles would be owned by Westar Energy, and we would be needing to coordinate with them on any kind of permitting or approval process. And you can keep going, John, and kind of walk our way through this if you'd like. So we have the equipment cabinets, and then these are just some illustrations of what they could look or be like. And what you will see is, in some cases, you'll see poles with the equipment boxes mounted to the pole itself, and in some cases that might not be the case. And so these are, again, what you might have with antennas mounted on the top of poles from a cross-section standpoint. That one is difficult to see. Again, these are photographs of different types of antennas. You have them in your packet so you can see, but this might be a typical installation where there's an antenna up there, but that has this painted shroud around it, which kind of camouflages the antenna, and that is the same concept that we have over at Kenwood Cove, where the antennas are actually inside the pole as opposed to being an exterior mount. And so this is a typical installation where you have a ground-mounted box. This would be a replacement pole. That is not an existing light pole or power pole. That's a existing or a replacement pole that would be placed there to try to blend in with the other poles and with a ground-mounted box there at the bottom. So you want to go to the next one, John. This is kind of dark, but this is a pole here, and then this box here is mounted to the pole 1 foot off the ground. So you've got your pole, you've got your antenna covered by a shroud there, then you have this equipment box for that. We do have representatives of Westar here, and two things we would like to hear from them is one, what their approval or disapproval process would be, and then secondly, we have heard secondhand that Westar does not want these types of equipment boxes physically attached to their poles, and we'd like to get some feedback on is that correct, and what is the basis for that. And I think we have some, if you want to keep going, John. These are just shop drawings of, this is a typical cabinet that would be attached to a pole, and we had a lot of discussion if there should be a minimum height, and we do have a minimum height in our draft ordinance, and that's to try to keep those boxes off the ground. The draft ordinance has been shared with the party that is most interested in obtaining a franchise to begin installing these in the public right-of-way. I have not received any feedback, but perhaps our city attorneys have. But basically, this very much parallels our process that we have for locating on private property. And in addition to getting some feedback from Westar, I would just kind of explain to you that if AT&T has 3 co-locations that they're trying to do within the city of Salina, and one is at Central High, and one's at South High, and one's on North 9th Street. Those are 3 different applications. They're processed separately and individually. Those are 3 different application fees. A determination about whether that comes to you for review or not is made on a location-by-location basis. Planning staff's concern about this is that applicants may come and try to bring 25 or 30 of these at a time, which would all be in potentially physically different locations. And in the planner's mind, that's 30 separate applications that could be approved, disapproved, or modified. In their minds, it may be one single application. But we would appreciate getting any feedback from you on that. But basically, what this is introducing and utilizing the public right-of-way as a means for establishing antenna networks, whereas up to this point, all of our wireless communication facilities have been located on privately owned land or buildings, except for the distinction being right-of-way versus we do have some on public school property and public park property, but they are not right-of-way. And so with that, I would be open to any questions you have, or if I've left anything out, I would defer to Mr. Bankston or Mr. Martin if they have something they would like to share with you in the way of reporting.
Any questions for staff?
I took it that these operated in clusters from the diagrams that we have. There's a certain number of them, but they are put together by some kind of a junction box or
Well, what
standing.
is if not part of this, but let's say if you had a successful system, and what the entities that we're working with, they are infrastructure builders. So their hope is that they will put the infrastructure in, and then service providers such as Verizon or Sprint or Nextech or AT&T will utilize their infrastructure. And then what you're going to have is that, and it's very hard to see, but at intervals you're going to need a building or of some kind, a shelter where, you know, this is going to be the equipment for Sprint, and this is going to be AT&T, and this is going to be Verizon, and there's going to be what I refer to as antenna hubs or clusters at different intervals, where you'll have antenna, and then serving that series of antennas, you're going to have a place where you have equipment, switching equipment, things at intervals. But the idea is that when cellular service first started, the idea was to get as high as possible and to get the geographic coverage so you didn't have dead spots. Now what is happening is that with the appetite for data and streaming and photos and texting and all of that, it's a capacity issue. So the network has to get denser so that the images and all can be passed on from antenna to antenna to antenna to add capacity to the system. So the way this could work is that you might have one of these that might be used. This one might be used by Sprint, and this one might be used by Verizon or whatever, but Sprint, Verizon, they're not in the business of building this infrastructure. They're relying on a third party to build the infrastructure, and then if the infrastructure's there, they'll make arrangements to use it.
From the point of view of the application process, and you saying that was complicated, they might have 25 at a time. Are you talking about the individual poles, or would you'd handle that as a cluster, wouldn't you?
Well, this kind of oversimplifies how close together they are. I mean, if there are 30 locations in the city, they might have this power pole, and they might have this power pole over here that's 7 blocks away, and this one over here that's 8 blocks away, and one on the east side and one on Broadway somewhere. So,
But wouldn't you service the application by the location of the hub rather than individual poles?
to date, our ordinance, the ordinance we have doesn't address the hub, and none of the, at least the discussions that have been to date with the infrastructure provider has acknowledged the need for constructing those hubs. I guess they'll cross that bridge when they get customers.
For coverage in Salina, is there estimated of a number of these antennas that are going to have to be placed, and estimated number of hubs are going to have to be to cover?
Well, I had some
capacity?
preliminary discussions with them. Their first wave that they want to install is 30.
Right.
And they've identified at least 46 potential locations that I'm aware of, and it may be double the 30, but their initial wave that they've identified. And you might want to also ask some questions of our representatives of Westar as to how that's being coordinated between their poles and this infrastructure provider.
So the city owns the public right-of-way, and Westar owns the poles. What are these guys going to do to convince the city and the Westar to allow this to happen? Is there going to be a contract that's going to be monetarily bound that would make it worth the public's?
I think what I'll defer to the attorneys to explain that, but we don't really have an option to allow or disallow it. It's more the basis on which we would allow it. And Westar is somewhat in the same position. They can't simply say no.
If you will, let me ask this question, which ties a little bit to what you just said, is how will this distributed network implementation, if allowed by the city, impact the investment, which is significant, that Verizon and Nextech and Alltel and some others have in those tall towers that we've put in at this point? Will this replace those towers in its entirety in time? And then their 30-year investment, what happens to all that? I'm just asking.
It will actually enhance the ability of those towers to function without the need to build additional towers.
Okay.
It's going to be a substitute for the need to build additional towers, because the density of the network is going to increase the capacity. And again, we're not talking, it's not Verizon and Sprint that are going out and building this network. It's a third party that's going to try to build the network and then market that network to Sprint and Verizon and them to increase their capacity and their ability to serve customers.
Yeah, I understand the nature of my question is the competition that exists using public right-of-ways, public domain versus private investments, and I'm concerned about that. So,
well, we could ask Mr. Martin or Mr. Bankston to address that, but we don't think that doing nothing or simply saying no, you can't use our right-of-way is not an option. So
The chair to ask Mr. Bankston if he would step forward and add some clarification to that.
Thank you, Mr. Chairman, members of the Planning Commission. Greg Bankston with Clark Mize Linville, counsel for the city. I primarily wanted to introduce Aaron Martin, one of my partners at Clark Mize Linville, who has assisted staff in this work in a lead role. And he mentioned he had not ever been to a Planning Commission meeting, so I wanted to be sure that all of you knew Aaron, and I'll let him elaborate on legal aspect.
Thank you.
Thank you, Greg. Thank you, Commissioners. I am Aaron Martin, and like Mr. Bankston mentioned, I have assisted Mr. Andrew and the rest of city staff in developing this particular proposed text amendment. And one thing that I think Mr. Andrews' staff report made clear, but that I wanted to reiterate, was that this issue is governed by federal and state law. The federal law allows the city to preserve its zoning authority over the placement of wireless facilities, whether that's in the public property or public right-of-way. And so we are allowed to regulate it from a zoning perspective under federal law, and that's what we're doing here. It's also governed by state law to the extent that the entity wishing to install the facilities is a certificated telecommunications provider by the Kansas Corporation Commission. And if the owner of the facilities is a licensed telecommunications provider, then they have a statutory right to place facilities in the public right-of-way, subject to the city's police powers to regulate that from a public health, safety, and welfare standpoint. So under neither federal law nor state law can we wholesale prohibit a provider from installing these facilities. And the ordinance, the proposed ordinance, has been drafted against that backdrop to ensure we're complying with both federal and state law. But Mr. Kennedy, to your earlier question about what sort of arrangement would we have with the owner of these facilities, depending on who it is installing them, again, this would apply to anyone wishing to install them, it would likely be an entity that has a statutory right to go into the right-of-way. And it may also be an entity that we have a statutory right to require a franchise from to provide the services. And we are aware of that, or are on top of that. Going forward, if there is an entity that wishes to place these facilities in the right-of-way, we would have a discussion with them about what they're doing and whether they are subject to franchising. And then once they've received the authorization to be in the right-of-way, each particular location where they were putting facilities would be subject to any public health, safety, and welfare requirements of the city, including this zoning code.
And including financial or monetary compensation to the city then?
To the extent allowed by law.
Okay.
Yes.
It's covered, specifically stated in
Yes.
law.
Depending on the type of entity and what they're doing, we may or may not be able to require compensation.
Mr. Martin, where's the free market get in on this? We're pretty much, we have to take them when they come. How do we get the best data, the most data for the citizens of Salina? I think my primary concern is that we have the best service possible so that we can compete with the cities that surround us.
Sure.
Is that an element in this, or this when they, because I understand the antenna laws, we pretty much have to accept their proposals in the long run because the federal laws force us to.
It's a highly regulated area, and the city is restricted from, requiring any sort of in-kind guarantees of service or anything of that nature. But given my exposure to this subject, I know that it's a beneficial technology, and that it's aimed at expanding and improving.
So how do we
the
know
network.
this first guy in the door is going to be the best service for us 10 years from now or 5 years from now?
Well, we don't. Any applicant, we can't guarantee that. And as I mentioned earlier, we have to consider their application and, assuming they comply with the city's requirements, allow them in the right-of-way. We can regulate the health, safety, and welfare components of their facilities, where they go, and if they're allowed in a location, what it looks like. But as far as the quality of their services, that's regulated by the FCC, the Kansas Corporation Commission, and those entities, and we have little control over that aspect.
You said health, safety, and welfare. Welfare would be a compensation to me. It seems like the public ought to have, if you're not controlling the consistency of their work, how do you know they're not going to come in and tear up your sidewalk, bury a cable, and cover it with gravel? I mean, how do we control that? Is it in the contract that says FCC going to come in and say this has got to be done to a specific way that our city staff and all is going to agree to?
Yes, there are standards that apply to work in the right-of-way. One of the things that we're not presenting before you today, but will be coming before the governing body of the City of Salina as a comprehensive right-of-way management ordinance that governs work activities and permitting requirements for excavations and restorations. So that would be a companion piece to this. This is simply the piece that applies to the above-ground pole and antenna, because that's unique to this particular type of service that we're talking about. The on-ground facilities and what happens when you dig and restoration requirements, those would apply to DAS providers as well as Westar or any other utility who's occupying the right-of-way. But there will be requirements, and there are requirements that govern that.
I'm actually curious as to, this sounds, I mean, and the way you talk about it, this is an enhancement of a service. Well, how are they going to determine what part of the city gets that enhancement first, what part of it gets it second? I mean, how do they make that kind of determination?
Well, that is up to them. That is not, the city is not allowed to dictate that. One piece of federal law is that we cannot effectively prohibit them from providing coverage where it's needed. And in the event that the provider can demonstrate that it has a coverage gap and it needs to locate in a particular area, the law mandates that we do what we can to accommodate that within reason. But we do not have the authority to mandate coverage in a particular area. That's up to the market to dictate.
Well, I don't want to necessarily have a side conversation, but, you know, when a sporting event is occurring at the Bicentennial Center, or any event is occurring at the Bicentennial Center, I'm going to guess that the amount of hits, if you want to call it that, per second in there is astronomical. That's going to require some additional coverage. Whereas the church across the street from me that has a couple activities in there twice a week, you know, so I think it's going to, that I think takes care of itself because of where the large number, I can see areas around schools and so forth where there's a lot of concentration of people who are using that equipment are going to dictate that as much as anything else.
What authority, I mean, why is this in front of us? It sounds like the federal government has certain things on there. So what authority does this commission have, or where is this going from there for us to say we do or don't want this? Or
The city has the right to regulate facilities in its right-of-way to the extent that they relate to the public health, safety, and welfare. And after conferring with city staff, the most natural place to put this particular piece seemed to be within the zoning code. It's already addressed for private property. And it's probably worth noting that the existing city code provision relating to wireless facilities on private property, they're subject to the same federal requirements as we're talking about here today. So we're operating under that same statute for private property and right-of-way. But the city does have authority to regulate its right-of-way for public health, safety, and welfare. And this proposed ordinance is aimed at doing just that. So all the considerations in here relating to height and aesthetics and locational preferences.
but if this provider who's putting this in met all of those parameters of what you're putting inside there, you have to allow it as per federal. Is that correct?
Well, the idea is that we have set up a set of performance standards that their installation has to meet, and if their installation meets those standards, then it is an administrative permit, which is fairly simple and straightforward. But the way this is structured, if they looked at the area east of Ohio and they said that, well, we can't find a real suitable power pole because they're all in the backyard and the streetlights don't work, so we would like to put in a new replacement pole as a support structure for an antenna, and we would like to put it in the right-of-way right in front of Mr. Kennedy's house. What that does is that pushes them into the category where they are in a special permit, not a administrative permit. There would be notice to neighboring property owners. There would be a public hearing in front of this commission. They would have to demonstrate that they've got a gap in coverage in that area, that the only possible solution is putting a new pole in front of Mr. Kennedy's house, and that they couldn't locate on a street light on the corner of those type of things. So the protection is there primarily for residential areas. If somebody puts an antenna on a power pole on North Broadway in a primarily commercial area and it meets all the criteria, then it's just going to go in like that. But when we get into the downtown area or to our residential areas, the state statute even says that the city have the authority to deny or prohibit the placement or use of the public right-of-way within a designated historic district. And the only way I can think of to do that is to have use the zoning tools that you have in place to approve or disapprove, to say, no, you cannot put, we have a designated historic district and you cannot put this in front of the Masonic temple.
You know, if I may, I want to go back to a point you made, because this is concerning to me. First of all, I want to be understood. I support this. I think it's a good idea. But I think there's some logistical questions here that I have concerns about. One thing you said is it would be up to the provider, basically, I'm paraphrasing, be up to the provider to determine where the best benefit was to put this in. But with other franchised utilities, generally they're provided to the city as a whole, to everyone, regardless of the benefit to the provider. And I think Westar, for example, has electricity to every home in Salina. Now, it may not be as profitable in some areas because they have to run a lot more line, they have to put up a lot more poles for fewer participants. So I think Cox is ran to every resident in Salina. It's not as profitable maybe to go to the Schilling area because the density is less and it's farther out there and it takes a lot more work to get there. If we allow this, would a provider be able to come in and basically select areas where it's very profitable and then ignore those that are not as profitable? I mean, I'm concerned about that. In other words, those people maybe living in the new additions of Salina might have great network coverage where those in the older areas of town may not have, and that doesn't seem to the welfare of the community as a whole.
Yes, and to address that question, the city is not authorized by law to regulate the areas in which telecommunications services are provided.
So, but that's not true with electricity.
I don't believe so. I haven't looked into that recently, but with respect to telecommunications services, the city does not have the authority to dictate which geographic areas.
Thank you.
So, Mr. Martin, I have a question very quickly. I believe I could be wrong, I think the Cox franchise fee from the city is 5% of their income. What's the maximum allowable city fee, franchise fee, percentage-wise? Do you know?
That is the subject of a negotiation, and it generally is 5%.
Yeah. Okay. And then, by the way, just a quick comment. We're talking about, if I understand the situation correctly, we're talking about a carrier using another carrier's poles to carry the signals of Verizon, AT&T, et cetera, not Comcast, Time Warner, thank God for us, but then we have, at the federal level, those companies deciding to charge twice as much or more for many faster speeds, and we're going to be relegated to the fast lane. So I would encourage the public, if they're listening to this, and the commissioners at large, to go to the fcc.com/comments under net neutrality and comment that we are mad as hell and we're not going to take it anymore. There we might have some say about the matter.
Mr. Box.
I have just some wonderful gems. To me, a pole is a pole is a pole. We have too many of them already.
Absolutely.
So we need to figure out a way to multitask those things as much as possible. Okay. A wire is a wire is a wire in lots of cases. And I think anytime if we're using fiber and so forth, there's a lot of stuff that can travel on a fiber, and I'm going to throw out a number and somebody out there is going to say you're all wet. But I would guess there's about as much capacity on a fiber that's not used that is used at this point. And so I think we need to find a way to pack that stuff as much as anything else. I really thought about bringing a picture I have. I think it's in some city in Japan in their back alley. And daylight is about wiped out because of all the poles and power and everything running all over the place. And so we've got to find a way to do that, and we've got to find a way for the various public utilities that supply all of us with the things we want, more than we probably need, but the things that we want, to do that in a manner that doesn't just totally, clutter the environment. Having said that, when we talk about aesthetics, and I've been dying to say this, nobody, I don't think, I should ask it as a question, do people come to you and say, is it okay to put a crooked pole in the public right-of-way next to someone's house, or do they all have to be sure that they're straight poles?
We don't have any...
It's meant to be silly.
We don't have any authority about where they're placed.
Or whether they're crooked, or if a crooked pole is in fact not very aesthetically pleasing, we don't do a lot to regulate poles.
We didn't on the overpass.
I think we have better things to do.
They have crooked ones on the overpass, so assuming that's okay.
Nobody asked me, is it the pole next to my house have the transformer on it, or is the pole next to my neighbor's house has a transformer on it? I'm sure those things do not come before the city of Salina. And I think we need to just back off a bit, or we'll be here till midnight every night.
Hear, hear. Any other questions for Mr. Martin? If not, I would open it up to the general public.
Whew, I feel better.
I think we would like to hear from representatives of Westar, what contact they've had with this carrier, what their process is for approving or disapproving use of their poles, and what discretion they think they have. And then our primary concern is if the carrier wants to use a Westar pole, we've got to have a mechanism to communicate with Westar to make sure that they have in fact approved the use of that pole. And then also want to hear to them the subject of attaching equipment boxes to poles versus putting them on the ground.
Is there anybody from Westar who would like to comment on any of those?
There is.
Name and address or representative for the...
Jeff Zerker, Westar Energy, Northwest Region, but I'm based here in Salina with our engineering and design group.
Okay. First, slower for sure again. What was your, did you get
Jeff.
that first name?
Jeff Zerker.
Jeff.
Okay, perfect.
I guess to address one of Mr. Andrews' questions, the whether or not, what process is in place right now to determine whether or not a request by a provider is considered. It's kind of a twofold process. We have contracts with, let me back up, there's a long history of attachments on our poles before this. We have many attachments that occur in a supply or a communication space, and that's governed by National Electric Code, National Electric Safety Code. This is the difference in these attachments. As you can see by the picture on the left, it's going up through what we consider our primary voltage area. It's a high voltage area, has many other safety concerns, and both logistically and operationally for us. So there's some differences there, but we have a long history of allowing many data and telecommunication providers to attach our poles to address Mr. Box's statement about the look of the right-of-way and aesthetics that are important to us. And so some poles can have multiple attachments in that communication space below our primary area, and many poles in Salina do, Cox and AT&T and many others. But to elaborate a little more on the aesthetics, so it's important to Westar that the pole, that what's in the right of way looks good in public image, public perception, that we're doing what's good for the communities we serve, and we have actually right now an initiative to even increase the aesthetic improvements and what we're doing in the public right of way. Mr. Andrew asked earlier about the kind of what requirements we have for these attachments, and right now I can only speak operationally because I'm with engineering and design for the region, but we have a group that actually this is part of their responsibilities are as a corporate level or as a global level for Westar, and they're out of our Topeka general office, but they administer attachments both in the communication space and these future attachments, and also been looked at by our standards engineering groups. But right now, if a user comes to us, yes, they have to have a contract in place, and I can't speak to whether that's an executed contract or just a request for attachment, and then the contract describes those attachments, but something like that has to be in place. And then those folks with our attachment group send somebody locally with our engineering in that region a request for attachment and to do a load analysis. And usually we use a third party for the load analysis. We send the various pole characteristics. They tell us what they want to attach, and we can make sure it works for those single instances. And I think Mr. Ryan had mentioned something about the whether it be a single permitting or a group of permitting, and that'd be something that we'd work out with the city, what would be practical to do as far as number and type, but we have to look at each location as far as whether or not it's a good sound engineering decision and structurally sound, and we look at, right now I think it is 30 to 40 requests we have for various locations in the city, and we'll look at each one of those to make sure that it's going to meet our requirements from an engineering standpoint and structurally and aesthetically. And
So if someone's sitting across from the table from me and they tell me that they have 30 locations that Westar's already approved, that might be a little bit of an exaggeration.
I don't believe there's any been approved right now. We haven't done any studies on any of those 30 locations yet. And it's still pretty new in the process for us. I think Salina is one of the first actually areas, even in our company, that's doing these. Although we have some great standards already from our standards engineering group, there is some other utility or some suppliers that have
pole by pole look at. I mean, you have to look at every pole and judge it worthy to hold these things.
True.
What do these antennas weigh? I mean, are they very heavy? Are they? I mean, you're talking about an engineering problem.
I can't speak to the actual weight, but they're not near as. And I was telling the city engineer, Mr. Stack, earlier, and gave him reference to what we have online, and it's available. It's public access information through our service standards.
In here someplace.
Through our Westar. I don't know if you have it there or not.
I got tired of reading it all, so I probably missed it.
It probably isn't.
We don't have anything from Westar in there.
It's through our public portal. It's available to all electricians and all anybody that's going to attach to us, and it's about 9 pages of information about the different criteria and technical issues. And it does show some typical antennas, and they don't look to be quite as substantial as some of the images up here. They're all pole top installations, and one of the requirements is they can't really be an extended above the pole top, as some of those were. But I think it would vary from requester to requester and what kind of equipment they wanted to attach, and that would be one of the things that's in our standards would control that.
What about pole-mounted equipment boxes?
I believe there's a requirement right now to have no more than 2 boxes on a pole, and if one of those is all these locations have to be metered, so we can measure the amount of energy flowing to each one, so that if they vary, we can build them accordingly. If one of them is a metered enclosure, they can only have one other enclosure, and then the size and type is regulated or specified. So really, it'd be two box attachments.
That was another conversation item, is that I was told that Westar won't allow any equipment boxes on their poles, therefore they all have to be on the ground.
Cox is up there.
Also, just have to get dealing with a little more detail locally, and they're talking about changing out every pole from a 5-foot taller pole.
I don't mean to interrupt you, but yeah,
We might want to have
you
you
want to
come
come
up
to
here and...
just so we get it on the record. That's
Jim.
Yeah, Craig Madison, I'm with Westar in Salina too. And I've been working with these people somewhat locally, the idea tech that was flashed at the bottom. And what the preliminary has been that we're trying to keep them on streetlight poles and secondary poles and overhead guy poles and off the high voltage poles as much as possible. But due to federal regulations, we can't tell them, no, you can't do anything. So, and they've given us like 40-some locations, but what we've been told, my supervisor has been to most of the meetings on this in Topeka, and he's on vacation right now, but what he's told me is that when we allow them on a pole, we're going to have to change it out to a class heavier pole and a 5-foot taller pole than is there now. So say it's a 35-foot class 5 wood streetlight pole, we'd have to go to a 40 class 4 at least, so they have enough room on top. Now, whether he was right or not, the number he had been told was that they're going to weigh about 40 pounds. So, I mean, we're just kind of, this is a new process. They're also attacking Hutchison, plus some other communities, but at this time, but best way I can say it, because this is not our, we did not go out seeking this, and we're trying to work through it because we're, like Dean said, we have to accommodate them as much as we can as well, so. But overall, it's probably for the public benefit, but, you know, it's like I say, it's going to require pole change-outs all over, and I've heard the same thing from our people, that we're not going to allow them to put the metering in on the pole and whatnot either, so. But there again, we're just working through the process as well.
Craig, I might ask you, Craig, if you don't mind, I mean, at whose expense would that change out of those poles fall on?
They're going to pay for it all, and actually, when Cedar, my supervisor, and I met with the representatives that have approached, that were flashed up there earlier, there was also one of the telecommunications company there, and actually, I think they will be the ones paying for it in the end. They don't want to say who it is, but they had actually 2 or 3 representatives there at the time.
So
and they're the ones actually financing this.
A typical wooden power pole in a neighborhood, what is the typical height of that pole?
35.
Well, we're back to a secondary pole or a street light pole is 35 feet. On the new poles we put in, we have older ones that are only 30.
Okay.
But
It really varies greatly, you know, if they, depending on what area they chose, you know, on what, if it was an arterial street or something like that, it could be, you know, we have everything from 30-foot poles that are below standard now to, and we would never do that again, to 65, 70-foot poles that probably wouldn't be very practical for them to install on. But it sounds like they, you know, probably average 40-foot pole would have to be increased to a 45. That'd probably be a median somewhere. So.
Somewhere in there, because there again, we're trying for everybody's benefit, because they don't have the people qualified to work. You know, they got to get the antenna above our stuff, so then they're in the primary area, which they don't have people qualified to work on.
That was one of the stringent requirements of our guidelines, were that they hire, they can't use anybody that's not a high voltage electrical qualified worker, and that's quite a bit different even from being an electrician. So they'd have to hire either on a proof contract or somebody that we would hire to even work on our own system in a time of a storm or a high volume work. So.
But there again, there's not much we can say. We just have to work with them also.
So,
Right. So
I think suffice it to say there'll be a lot of communication and coordination between Westar and city staff.
Ultimately, if we pass this ordinance, these problems that they're discussing, though, start to turn the thing back to the way we've been for 120 years with transformers on poles. The city has never approved or disapproved the actual placement of the transformers in the Westar distribution system. It's kind of implied in this that we might have some say on the distribution of antennas in this system, but they're still going to look about the same as transformers. They are a lot lighter. They're probably about the same wind resistance, and all those technical problems of the fact that there's going to be more wind resistance on that pole, and there's going to be more ice load when we have ice storms, and more potential for disruption of our electrical power. All that falls back on these guys.
It'd be a liability, but that's part of the load analysis study that we do. We look at criteria not for a perfect day like today, but what
an ice storm followed by 60-mile-an-hour winds.
And we designed a wind and ice factor for all of our stuff. Even our conductor we hang has to be a 40-mile-an-hour wind and half-inch ice, or excuse me, not a 40-mile-an-hour, but 4 inches per square inch and a half-inch ice.
But in the last 100 and some years, this planning commission of various cities has never had anything to do with any of that, and I just find it kind of strange that all of a sudden we do.
But the thing you have to also remember is that in many of these locations, they don't wish to use an existing pole. The other thing is that we have an underground wiring ordinance now, and in many of our new areas, we don't have very many existing poles that you can hang anything on. So then you're going to be in a situation where the service provider is going to want to put up a new pole in front of Mr. Kennedy's house, and then the question is, does it have to be there, or can it be somewhere
Well,
else?
are we
But the
going,
beauty of that
are
is
we
if they
going
put
to,
that
under
there-
this proposed ordinance, are we going to be looking at every pole as a separate application to
Yes, a
this
replace-
body?
A replacement, not to this body, but if it's a replacement pole that's a new support structure in a residential neighborhood, then the answer is yes.
We get to look
But
at
it's not, the word replacement doesn't fit in that sentence.
or an
Replacement
additional.
implies there's already a pole and a bigger one's going to go in, as opposed to
Well,
a
then
additional pole.
a replacement may also be a new installation because they can't find a pole that's suitable.
It says in here, the attached ordinance contains following elements: pole height, maximum antenna height, maximum pole circumference. We aren't going to make any decision on that at all. You guys are. Right. So that'll be determined by you, and then we have to, I mean, how's our ordinance?
Well, like Dean said, there are, from my understanding and the conversations back and forth, there are locations where we cannot find a suitable pole for them, and so they are going to attempt on their own to provide a pole, and we will not be involved with that.
That's correct. There'll be a number of these cases that Westar will have no involvement whatsoever, and the involvement will be you.
And do they have to use a wooden pole versus a metal pole, or does it matter?
That's up to you.
Now, are we talking about this commission, or are we talking about staff?
Will be able to serve
Talking about
But Westar's not going to supply power to a substandard pole. I can't put a piece of bamboo up and hang a 40-pound deal off of the top of it and have them run power to it. So I think we've got some checks and balances here, and I vote, let's don't get too micromanaging here. Let's.
Yeah, like, the discussion early on has been that we would meter it off the pole, so you're back to.
have a pretty good pole to meter it on.
Our hope,
No, you do it underground on a meter stand.
our hope is that
Independent of the pole.
80% of these installations will be something that's just between staff and Westar, and your role would be in those 20% situations where they can't find a support structure and they wish to place a new support structure in the public right-of-way. What you have to understand is, even though you're mowing it and you take care of it and everything, you, as an individual property owner, can't say yay or nay to a pole or post being put in front of your house. However, you as a planning commission and a reviewing body for the public health, safety, and welfare can determine whether that's the most appropriate solution or not. That is what is proposed here, and that is what your role would be, only in the situation where there's no Westar pole, there's no place that's suitable. They want to put up a new support structure in front of somebody's house, and that has to be reviewed by you to make sure that's the most suitable location and the most suitable pole design.
Right.
Well, you know,
But we're
obviously,
glad
there's
that
a
you're
ton
going to
of-
be there 80% of the time.
Well,
Thank you for your
thank you. One last thing, Dean, if somebody was sitting across from the table telling you that we've agreed to 30 locations, that's, to my knowledge, is not true at all. So.
That's what I was told, so I thought I'd ask.
Needs to be a strong pole, because my weed whip is cut into your guys' pole pretty bad.
Yeah.
All right.
Thank you for your time. Mr. Bingston, have additional comment?
Just a little bit at a time.
Thank you, Mr. Chairman, Commissioners. The point I wanted to make quickly, you are in the context of a text amendment, as you know. It happens that the eminence of a particular applicant or application had much to do with the timing of that, frankly. The technology is new, the technology is coming, and the technology will be with us soon. Wanted to be sure that you know that staff, nor Mr. Martin, nor I are trying to be coy with you at all. We do know a little more than we can tell you about this particular applicant. We have to be respectful of, there are proprietary aspects in what, as you can imagine, is a highly competitive environment. But the aspect of what would ultimately, in most cases, involve a franchise, as that would be dealt with by the City Commission, is where any of that information and consideration is given. So I wanted to assure you that nobody's trying to hide the ball from you in terms of the specific applicant or anything that we might know about that. And I trust you would be aware that in the context of this text amendment consideration, we do know that the City Commission would like to utilize the city's zoning capability to address this technology in the right-of-way. And I think maybe this latest conversation, it's a technology that takes a little while for everybody to kind of warm up to and anticipate its arrival in the context in which telecommunications are upon us and in a very busy right-of-way. But I think this latest discussion, I think, was getting us to where the matter of the application of the zoning code will truly apply as this technology is with us. So just wanted to make sure that you knew that we're not talking about the particular applicant any more than we frankly have to, because it will relate to the current applicant and all to come. So we need to keep the conversation on as general a basis as we can, given the technology. Thank you.
Anybody else from the general public like to speak at this time?
Good afternoon. My name's Richard Gato. I'm with Next Tech Wireless. As you know, we've, in the last couple of years, made a major investment in the Salina area. And I would like to tell you that we wholeheartedly support the concept that is before this board today. It is something that we actually looked into when we did our initial build-out in Salina, and because these policies and procedures were not in place, we met with a lot of resistance. Westar was, fine to work with, but, it just wasn't, the timing wasn't right, if you will. So this will improve the coverage area, whether you're with Nextech or another carrier, and it will allow for less what we call macro poles, which are the big poles, because we can now target gaps in coverage where we couldn't do that before. Every carrier knows whether they would like to improve their coverage, and this will allow us to do it at the least intrusive way we can and make it easy for everyone. So I would just encourage you to, we aren't the ones that don't put the cable down below the ground, but we would use it if the option was there, and I would encourage you to seriously consider this option. And I'll stand for any questions.
I particularly appreciate you coming to the commission and sharing that, because it's important for me to know that the private providers such as yourself endorse this concept, at least initially.
Yes, and I will tell you that this concept is growing nationwide. Yeah. We go to trade seminars, and it isn't talking about towers anymore. It's talking about what we call DAS systems, small cells. That is the entire conversation. Macro and micro towers are almost a thing of the past. This is the future, and I applaud you and the city staff for looking at it and setting up some procedures to make it easy. I will say one thing. We do have an agreement with Westar to locate on poles. When we looked at doing it in Salina, we went ahead and initialized and completed that agreement. And to lay your minds at ease, Westar was very strict in what they do and do not allow. Sometimes you wonder if it's the bureaucracy or what, but they were. So, they're looking out for the best interests of themselves, but also the customers that they serve. And, we were kind of the last person on the pole, if you will, so, and the least important. Yeah, and we recognize that. That's okay. But, because we don't want to take down power to an area or anything else, so.
Well, I think that's my concern a little bit. I've dealt with, and you were saying the bureaucracy, sometimes I would rather erect my own pole than have to go through getting the approval of, and that's my concern on there. It may be less expensive and faster to start erecting poles in town than it would be to go through the process of getting them to okay that I can put on certain poles. Is that a concern at all?
Well, I would tell you that even though they have a bureaucracy, and you know, it's Westar, it's a major corporation, it's a lot easier to go through them and try and get an administrative permit than to do the process as if it went in front of the Planning Commission and then the City Commission if that was required. I think that we could work with Westar and work with the city staff to address those concerns. From my experience about the DAS system, it is not, you know, if it's this pole or the one 30 feet down, doesn't usually matter too much. Now, as I say that, I'll probably be back here in 6 months saying we need this pole. But as a rule of thumb, there is some flexibility. It was noted earlier that there's a lot of poles in town, and there's a lot of poles to be used. So there is some flexibility for the users, I think.
Any other questions for him? Thank you again for
Thank
showing
you.
up. Appreciate your comments. Still open for public comment if anybody else would like to address the commission at this time.
And I just, again, wanted to clarify that in addition to this, the actual text amendment that sets up the process, the only type of case that would come before the Planning Commission for a public hearing is a case where there is no streetlight pole, there is no utility pole, and I want to put up a brand-new 40-foot pole in front of somebody's house in a residential area. That is one where the Planning Commission would have a role on the final location, the height, the construction material, those type of things. And that hopefully is the exception, not the rule, and that most of these will be administrative permits on existing poles.
This time I'd like to close the public hearing based on nobody coming forward, bring it back to the commission for more discussion or possible action.
Mr. Chairman, I move that we approve Z 14-5, the text amendment as printed.
Including the staff recommendations, which are also on page 5 of that report.
We think that if you base your action on those findings that are set out there, that will, and those are attached to your recommendation, that will help strengthen our position and our reasoning for why we're using the zoning authority for this.
Yes, including those recommendations as printed.
I second that.
I have a motion and a second. Any other discussion?
I do. One thing, and this may be the only time I might say this, I think Mr. Kennedy brought up a real important issue, and that's an issue of equity. And I grew up in a really rural area, and at one point along the way, if the REA hadn't put a wire out and made it something that my folks had to pay for, we'd have been in the dark still. And I think their small communities have struggled with connectivity, especially in northern and western Kansas. And if we didn't have strong voices for that, they wouldn't have the technology they have now. Getting closer to Salina, we have areas of Salina where we have a concentration of lower socioeconomic families, and if it's left to their clout politically or economically, they will not have access to this either. USD 305 has made a strong commitment to provide all of our secondary students with a wireless device so that they can get online and do things at home and wherever they're at, but they do have to have access. And so as we go through this franchising type agreement at some point, I hope that we hold those companies' feet to the fire to be sure that we do have access for all groups, not just those groups who happen to have a big voice or a big pocketbook.
I think based on Mr. Martin's thing, that may have to change federal level prior to that. We have no discretion of where that can go, but comment duly noted.
Yes,
I have
and
a
I would second that.
Yes, and you have the
comment.
website to prove it, so you can go do that, www, whatever you said before. I have a motion and a second, and I'm looking for all in favor. Any other discussion? Indicate by saying aye.
Aye.
Opposed? Motion passes. Thank you again for your time for showing up. We're going to move on. Public hearing item number 3 that we've rearranged here, filed by the Salina City Planning Commission requesting amendment of article definition by adding section 4216801 to electronic cigarettes.
Thank you, Mr. Chairman. We have put in your packets, they're right behind the staff report, kind of a multi-page framework for evaluating issues and options for regulating hookah establishments and e-cigarette establishments, and that was more for each commissioner to kind of ask yourself those questions and how you best felt that those were addressed. But we have provided you with the framework and a lot of background information. There's been a lot of discussion about this and a lot of background material there. But I'll just give you a synopsis that we, as a staff, looked at this. We looked at how we address downtown bars, how we address tattoo parlors, how land use decisions can interact with law enforcement and give law enforcement tools and mechanisms that they need. And so setting up a conditional use permit review process for e-cigarette establishments, we think provides a level playing field for them without prohibiting individual establishments. It gives you an opportunity to look at those on a location by location and case by case basis. It provides some flexibility in terms of the ability to look at the context that the location would be at, and also to attach appropriate conditions and enforceable conditions. And that's something that relates to law enforcement, as the city of Salina does not have a business license program. In other words, you don't have to have a business license to open a mortuary. You don't have to have a business license to open an insurance office or to occupy a commercial structure, and you don't have to have a business license to open an electronic cigarette shop. But what the conditional use permit does is it kind of serves that same purpose. And if you have a business that can't seem to comply with state or local laws, that conditional use permit then becomes revocable, and it becomes a tool that if there are bad actors in a particular industry, that it can be addressed through the conditional use permit. So the ordinance amendment that we have to present to you, first of all, has these definitions in them. We wanted to be sure that you understood that a convenience store or a grocery store or a drugstore that happens to stock or sell electronic cigarettes would not fit the definition of an electronic cigarette establishment. And so an electronic cigarette establishment would be one that's primarily dedicated primarily to the sale or on-premise use of those devices. And CVS Pharmacy or Dillon's is not an establishment that's dedicated primarily to that purpose. And so it would be narrowly tailored for those. We think it's important to have a definition of hookah establishment as compared to the electronic cigarette establishment, because as we discussed thoroughly at your previous meeting, the primary distinction is that electronic cigarettes, there is no prohibition either under state or local law that would put the use of electronic cigarettes into the category of smoking. Smoking is prohibited, but smoking involves smoke and burning and combustion. And electronic cigarettes do not involve smoking, burning, or combustion. And the use of hookah through the burning or combustion of tobacco or other plant material does involve that. So we think that is a distinction. And so the recommendation that we had was to basically follow the pattern that was used for tattoo parlors and for using those as an allowed use in our commercial districts through a conditional use permit in the C2, C3, C4, C5, and C6 districts, and allowing them as permitted in our I2 and I3 districts, just basically replicating what was done with tattoo parlors. And so that is the proposed change that would adopt those legal definitions for those uses and then allow them on a case-by-case basis in our C2, C3, C4, C5, and C6 districts. So we don't have a lot of C2 districts. The little shopping center across from Dillon's that has Papa John's and the chiropractic clinic, that is zone C2. So that would be allowed in there on a conditional use basis. The Galaxy Center is zone C5, and that would be a permitted location based on approval of a conditional use permit. C4 is our downtown area, so that would cover the existing vapes establishment, and then much of South Ohio and some of Crawford Street and South 9th Street is zone C3 shopping center district. And so that was the recommended regulatory setup. And the way that we looked at it and reviewed all of the literature and everything that's been provided is, at this time, electronic cigarettes are a lawful product. They're not considered smoking, either by sale or use. At this time, there's no documented health concerns about secondhand inhalation of vapor. There is some concern about over-concentrating them in one place and also proximity to children's activity centers. On the other hand, all the literature would indicate that there are documented health risks associated with hookah smoke, and it's very difficult, if not impossible, to monitor once a hookah establishment is in business whether they are smoking tobacco or tobacco products, and if they were, that would be a violation of our smoking ordinance. So our recommendation is through the land use to recognize electronic cigarette establishments as a lawful use, and to continue basically with not listing hookah establishments as a permitted or conditional use. So we've given you there some options. Certainly you could decide that you do want to treat hookah establishments and treat them on par with electronic cigarette and tobacco shops. You may decide that all of these should be permitted instead of conditional uses, or you may decide that, for instance, tobacco shops should be permitted and not conditional. But our thought was we have very few true tobacco shops, but that they have many of the same characteristics as electronic cigarette establishments, and in most cases also sell electronic cigarettes. So the idea was to treat them with a level playing field. So our recommendation would be alternative one, which would be to create electronic cigarette establishments as a lawful conditional use, tobacco shops as a lawful conditional use in commercial districts, and you would serve as a filter for those locations, and that hook establishments would continue to be a prohibited use in the city from a land use standpoint. So with that, I'd be open to any questions the commission might have on the subject.
Clarify for me, if you will, Dean, what are we saying here? Does that mean electronic cigarettes will be allowed to be utilized indoors in the city of Salina, in bars, in this meeting room, in these shops if they're approved?
Technically, they already are.
Okay, so they can be used?
Yes. That they're so new, and for some users are even, they're just conscious about that and reluctant to do that. There are individual businesses, corporations, Applebee's is one, they don't allow electronic cigarettes to be used in their establishments, but that's not based on an ordinance, that's based on their company policy.
And then in the tobacco shops, can you test the product in the tobacco shop then?
No.
No. Okay.
Not in Salina.
Even with this change, we still
Even with
couldn't?
this change.
Okay.
So you'll have lots of sampling going along of the electronic cigarettes, and again, that's partially what is confusing, but under state law, you could be a tobacco shop, and as a tobacco shop, you could allow customers to come in and sample cigars, cigarettes, pipes, things that involve smoking indoors, but the Salina's smoking ordinance does not have that exception.
But they could sample e-cigarettes.
They could sample e-cigarettes,
Or we can use them in here.
or they could use them in here. Yeah. Absent some change to our smoking ordinance or our building authority policy, since the use of e-cigarettes is not smoking, you would not be violating any smoking laws.
Yeah, zebra by any other name seems to still be a zebra to me, but maybe I'm just wrong.
That's not tobacco, though.
It's not tobacco?
Vicks inhalers.
I thought it was,
in the stores,
Yeah,
and you know, because you got a stuffy nose.
that's
I
what,
can smell those. The Vicks ones. You can't smell the
e-cigarettes,
the other ones.
and there's no harm to anybody around them. Weird.
The interesting thing is, I don't know how many you've actually been in any of the vapor lounges or whatever.
Obviously not many, because I'm asking some pretty stupid questions.
I just went this afternoon, and totally unannounced, not for any special purpose other than.
May want to use your microphone there, they can't hear you.
No, I think I went this afternoon, spent some time at Vapes right over here, just to ask them what they do. The room as it's configured has one high four-top table and a couch. But it's primarily just a set of counters where there are various kinds of electronic cigarettes that you can buy, the mechanisms, and then a lot of little bottles of juice, if you will, that you can put in them. It wasn't like the den of iniquity that I thought it might be in terms of just tens of 20 or 30 people sitting around smoking these. And the other thing that was interesting, there were two individuals in there who were using, or vaping, if that's the right word at the time. And the only reason I knew they were vaping is that I could see them exhaling it. Otherwise, you didn't smell a thing. I was amazed.
Great. Any other questions before I take it to public comment? Seeing none, I'll open it at this point for public comment. You've waited your turn, I know. We've moved the whole agenda around, so.
Mike Pruitt, Mentor, Kansas. Consider myself a Salina resident, and I know it's been a long day for everyone, so I'll be brief. I just agree with everything you guys are doing. I am still very interested in opening an electronic cigarette store in Salina. Our feasibility study was done about 8 weeks ago, and this is a dynamic industry. We've seen lots of change, continuing to see things change. But I agree with Jerry here that it's so less intrusive than smoking cigarettes as far as secondhand. Personally, I disagree with people that would sort of hold it out in front and do it in places that smoking is not typically done at all, you know, and be rude with it, you know. The other thing that we've seen is the study that we did, as you guys know, a business has to be based on its feasibility to bring in a profit, and what we have seen in this industry is that businesses that cater specifically to the electronic cigarette store are continuing to do well. What we were seeing 8 weeks ago is quite an explosion. In the last 8 weeks, as you've probably seen at all your gas stations, your Dillons, Quick Shops, the little Cigalite electronic cigarettes are growing in popularity. And that's because of big business getting involved in this trend. But what we're seeing is every community, I have friends in Texas that have these businesses, I have friends in Oklahoma that have these businesses, and it depends on a community perception. Because my perception, and the thing that I'd be interested in promoting, is an electronic cigarette establishment that assists people in quitting regular cigarettes. It's done wonders for me. It's done wonders for some of my lifelong friends. The perception that we're seeing is all of a sudden they're available at every gas station you come to, which is driving the price way down. The ones that are available at the gas stations are, you know, of a nature that they're not, what would you say, not as strong or not as effective necessarily in helping people quit smoking. So really the general perception among smokers, adult smokers as a target for business, has to be, and in different communities it's different, that, oh, well, the higher end, so to speak, vaping equipment and juices is more effective than the little Cigalites you see at the gas station. And so what we're seeing is, in this community, it seems like most smokers are saying, oh, this is interesting. They're trying it in a product that's not, in my opinion, as effective as going to vapes or going to juices and trying the more powerful smoking substitute. And so we're going to, at the time that you guys allow this, we're going to, you know, conduct a new feasibility study and see if this community would support a business that's target is adult smokers who want to quit. And that would be the premise of any business that I'd be involved in. And so I just wanted to say that and say thank you guys for being so logical and everything here, and we're all looking forward probably to dinner by this time. So
yeah. Just so you get the timeline, Mike, the idea is that there would be a recommendation made here. That recommendation would go to the City Commission for actual ordinance changes. The moratorium that's in place is actually scheduled to expire the 15th of August, and that was based on the timeline that the pending legislation would be adopted by that time. So our hope is to be accepting applications or locations as soon as that moratorium expires.
Again, Mike, thank you again for your time and your patience with us. Anybody else for public hearing? If not, I will close the public hearing, bring it back to the commission for action and or discussion.
With the use of a hookah as an ancillary activity, and I'll use the Club 111 as an example, would that be permitted? Just something else going on there, like playing pool?
I think we had that discussion with Mr. Bankston. He might want to weigh in that as well, but basically the minute somebody brought a hookah pipe with tobacco into a lounge downtown, that would convert that lounge into a hookah lounge, because
but they have smoke tobacco, right?
Yeah, so it's not permissible to bring a pack of cigarettes into the brew pub downtown and smoke cigarettes, and it would not be permissible to bring your own hookah pipe into such establishment and smoke tobacco through a hookah pipe.
But if they're smoking tea and the other fancy things that, I mean, they don't smoke tobacco.
They do. They can.
Well, the one they were proposing, I think when they were here, were saying as long as there was no igniting of tobacco, I think then,
I don't
and
know
that's,
how you smoke a hookah without having some combustion happening.
that was the debate we had.
Electronic heater didn't get hot
That's the
enough.
distinction.
That's the, Greg Binkson, legal counsel for the city, that is the intention of that language that refers to combustion, burning or combustion of tobacco or other dried plant material, and the ingestion of smoke. The distinction between that and the definition of e-cigarette, which you can read. So I don't know if there's anything else that they could burn. If there is anything else that we're aware of that they could actually burn and generate the smoke, we need to get it in there. But it was intended to reach. And I don't know about you all, the light somewhat went on with me in terms of the apparatus when the gentleman explained at your earlier meeting that, you know, you can have something that looks like a hookah pipe, but it may still involve just the vaporization of the juices or whatever liquid might be involved. But that the true, as we would understand now, the true hookah process involves that combustion and the inhalation of smoke that, albeit cooled through that system, still is the inhalation of smoke coming from either tobacco or other dried plant material, and that is what would be prohibited in any circumstance.
So the idea is that vaping through what looks like a hookah pipe would be okay, but smoking through a hookah pipe would not be okay.
That's going to be hard to
Even though you're
clarify.
not smoking tobacco.
Any other discussions or?
Unless you want to go in there with your chemical analysis kit and determine whether what they're burning contains any tobacco in it.
Dean, is
I
there,
don't want to, but I think they ought to have the right to smoke it if it's not tobacco.
there isn't a place in this amendment to do anything about age of entry into these establishments. Now, would that be something that could become part of the conditional use request? That are things that, if those things come back to this commission would have an opportunity to say, we can do that with the condition that no one under the age of 18, or whatever the legal smoking age is
The state
in
law is
Kansas.
that they can't purchase or possess, but if you wanted to say, we hereby grant this conditional use permit for this e-cigarette establishment, and as a condition of approval, no one under the age 18 can enter, then that can be a condition of approval if that's what the commission desires.
That's the place that could happen.
That's the place to deal with it, is on the individual approval basis.
Chair would entertain a motion if there's no more discussion.
I'm just not sure the tobacco shops, I don't feel good about telling a tobacco shop they have a restricted use when you allow tobacco to be sold in so many different places.
Doesn't it go back to the
You're going to restrict Laura's from being open?
purpose of the business or the primary sales?
Yeah.
What
50%
we have
of a
we've
floor
learned
space.
by observation is that and it's because of changing market dynamics, but the inside of Pack Rat Smokes, which is a tobacco shop, is not much different than vapes or juices from the standpoint that the smoking selection is now more confined, and they are stocking and marketing the electronic cigarettes and the vaping juices and all on to a greater extent. So there's almost a cross-pollination there. That is certainly within your discretion as part of the motion to say you think that tobacco shops should be treated differently than electronic cigarette establishments. Our approach was to take a level playing field approach across the board and to treat them the same.
So the electronic shop, because they do 100% of that business, would have to jump through more hoops than if a new service station started carrying the same exact same item. If he's carrying the blue cigarette and he's carrying the blue cigarette, one has to come through this commission to get approval, and one can just do it because it's not 100% of their business. Is that, I think that's what John has the concern with. So however you write that in there, that's, or however you want to respond to that, I'm not sure what the temperature is of everybody up here, but I know John's feeling on that is, and I'm somewhat a little bit the same way of saying, it's, I mean, if it's okay for them to sell the blue cigarette, why does this guy have to jump through 9 applications and sit in meetings this way to do the same thing?
Because one is primarily in that business. The other thing that it involves is also what the vaping shops or vapor lounges have that the others is the ability to go in and sample and to have the mixed juices and all that, or to just go in there and use it as a place to congregate, which is not something. You cannot go up to the Dillon's fueling station and sample different juices, or go inside and vape and do those things. So it's the level of the concentration.
But you could, because you just said that we don't control indoor use of electronic cigarettes. So you could buy them and try them in Dillon's.
Right.
You can use them in Dillon's.
Right, but you're not going to find a juice bar
Yeah,
in
I understand.
Dillon's.
I understand that part. You're not finding a juice bar. You can try that.
Be next to the deli bar soon,
Yeah.
maybe.
It-
Buy a little sushi, a little salad, and vape.
It is possible.
Where tobacco's completely different. Tobacco shops, you can't try tobacco indoors anywhere in Salina, but electronic cigarettes, you
Right.
can.
I have closed public hearing, but I appreciate your comments enough that I will allow you, if you have something you want to add to that, because I think you have an expertise in it, so.
Just in the context of what you were just saying, the typical adult smoking customer who would be benefit would come into a electronic cigarette establishment, and in there they would have a selection of equipment and a selection of flavors that they could try, and some of those would actually have nicotine in them. And so it's that experience and that level of customer service, and then the education that would go along with it to say, you don't have to smoke regular cigarettes anymore. And you can give examples, you know, first-hand examples, and so you can't do that at the gas station. You know, they have a product for sale. Buy it if you're bold enough. Try it right there in front of people. But the idea of an electronic cigarette store would be more of a one-on-one customer service, in my opinion, to encourage people to take the plunge and go ahead and get off at tobacco. So
My question to you would be, my question to you would be, do you believe that you opening up a vape shop, you should have to jump through more hoops than Dillon's?
well, no, I personally, I don't. I think that you know,
Because
we
people
should
come in and sit there and maybe can vape longer,
yeah.
or that it's a hangout destination for you, which is
Yeah.
what Mr. Andrew was saying down
Well-
there. Like, do you believe that you should be, in my words, penalized because people can hang out there and have access to more things than Dillon's?
Well, I don't know that I'd look at it as being penalized. You know, it depends which side. If you look at it as an opportunity to offer that exclusive service of taking an adult smoker and showing them an alternative. That's a service that you don't get at Dillon's or at the gas station cigarette counter. And so I think a lot of those, you know, and it is such a dynamic industry now. It's, you know, exploding in some places, it's not. That it hadn't settled out. I mean, we don't know what the picture's going to be. Theoretically, I mean, could a CVS pharmacy wind up with a vape bar where people can try flavors and say, "Ooh, I like that one"? I don't know where it's all going to settle out. But right now, the idea is an exclusive place where you can help people try before they buy, so to speak. And so as far as it being a hangout for vapor people that are into it to just spend half a day, I know that could happen, but what I practically see when I go to Manhattan and visit vapor stores, all the way out to Garden City and visit vapor stores, is it's kind of a try before you buy. People come in, they try it, their friends tell them about it, they come there, sort of an exclusive type business, and that's one of the things that makes it appealing as a business, is that there could be a whole new clientele of switching people from tobacco to electronic cigarettes. It all depends how it really winds up going. So we're watching it real close.
I agree with you completely, and I want to make it short, but you also have to look at the other side of it. Now, you have 18-year-old kids who have never tried a cigarette can go ahead and get hooked on nicotine because they're on vapes.
Well, that's true. That's
So,
true,
you know,
and I'm all in
watch both
favor
sides
of
of
the 18 and above.
18 or above.
And so, maybe at vapes, maybe at Juicy. See, I don't know, but the people that I know in the business really watch for that. In Texas, my friends who have these stores have, if someone looks under 18, they card them, just like you would at a liquor store if they're under 21. And so you got to guard against that. But
Great.
But depending on trends and what kids consider as cool, that could happen. Hopefully not.
Again, thank you for your time.
Thank you.
Again, would look for any type of action or clarification, or if nobody feels comfortable enough making a motion, then to table this for additional information or more studying.
I think that the market is small enough. We haven't had any trouble with the 2 vacant. Have there been complaints with the 2 vapor lounges in town thus far? Any unusual police activity or anything like that?
Eyebrows, but I can't say that there have been actual complaints.
I haven't heard of any either. I was just thinking that maybe the best way to go is to go ahead and recommend that hookah establishments not be allowed, since we don't know what's in that pipe that they're smoking. And smoking is not legal in Kansas generally, and in Salina specifically. But that the e-cigarette establishments and tobacco shops are not that radically different from any other retail activity, and that probably should just be permitted in the C zones and the 2I zones without even going for conditional use permits. Because I don't think there's that big industry out there that it's going to generate a nuisance. The object of having an age limit probably is worth it, but we could make that age limit universal. You have to be over 18 to enter or purchase.
Abner, there's an option 2 here of definitions, and does that option 2 basically state that hookah establishments are not, or by definition, are not going to be allowed?
Well, the difference between option 1 and option 2 is that option 2 says that hookah establishments would be something you could apply to have as a lawful use, just like an e-cigarette establishment. What Mr. Perney was recommending was really more item 4, or option 4. He's made a motion that the Planning Commission recommend that e-cigarette establishments and tobacco shops be classified as permitted uses, and that hookah establishments be prohibited.
Right. That's not actually pre-printed in here at all, but it's close.
Sorry, you've got a different packet than I've got.
I'm on a different page or something, huh?
Read number 4 and see if you like that.
That number 4, the Planning Commission could recommend that electronic cigarette establishments and tobacco shops be classified as permitted uses, and the hookah establishments be prohibited in the, that's the way I was going.
Is that where you're headed?
But with an 18-year or older age limit.
And I'll second that.
I do have a motion and a second, and I will allow council to move forward for the city.
To tell us we can't do that.
Yeah.
It's too easy.
Well, that's a fair statement. The point I wanted to make sure that we addressed, and I'll look to Mr. Andrew to confirm whether he believes my observation to be correct. The imposition with the current motion, and yet the desire to impose the age limitation, am I correct that we would have to move to a business licensing format in order to impose that sort of age limitation, that would not be something to be able to be accomplished through the zoning code?
we have what we call permitted uses that are also provisional, that says it's a permitted use provided that, to me, it would be somewhat like mixing apples and oranges to try to use just the general use regulations in a zoning district to prohibit the age.
But then you say if we go conditional use, we can put age limit on as a condition. So what's the difference?
You can't sell cigarettes to anybody under 18, and they can't buy e-cigarettes either.
Right.
Yeah, isn't there already a
There's already a
federal
law that says you can't
that
buy
says
them
that?
anyway.
What's the state of Kansas, so I don't even know why you would need to make that in
Okay,
there.
so we
if the
don't need
state
to
of-
do it. Okay, that
State
was
of Kansas already says you can't sell it to the under age 18.
Well, I understood we were, well, that's maybe I misunderstood the concern of, and if Mr. Perney, was it age as to purchase or age as to presence in the?
Well, I was thinking both.
Yeah, and
I
that's the
thought
one that's
maybe
probably,
because-
What's prohibited
Yeah.
is purchase and possession. What is not, there's no prohibition in any law that keeps a minor from going into an e-cigarette establishment. They just can't buy anything.
Yeah.
That's just a lot more regulations, and that's going to keep the
Okay,
police.
so
But-
I'll take
Give it a
the
double
18
duty.
age limit out?
Yeah, it would be much cleaner if you did not mix the age limit with the classification of the use.
The entering of the establishment is an age limit, because there is no age limit to go walk into Dillon's, which we were comparing
Right.
Right.
apples
And my
to
second
apples.
agrees with his amendment to
His ruling.
the,
Well, we don't have to.
second on it?
I have a second, but
We're
my
still for
second
discussion.
would amend his motion to put an age limit in.
So we eliminate the age
Eliminate
limit,
the age
but
limit.
make it a permitted use in all the
So I have a motion
C
and a
I
second.
zones.
I have a motion and a second on the new motion to amend the age limit, and with nothing inside there, and now I'm open for discussion. Mr. Voxa? We already have a second. I'm going to entertain a a roll call.
I'm going to vote against that, not because I'm against e-cigarettes or anything like that, but it doesn't give us any leverage at all. And my question in my statement that is,
speak up.
how hard is it for this body or another body to take something off of a conditional use? Let's say that we did, because I'm waiting this to become a conditional use, and at some point in the future, it may become a moot issue, and we don't need to make them conditional uses. But here's an opportunity right at the front end to potentially say 18-year-olds can't enter, no food or beverage will be served, to cause people to linger longer. Sorry, Kansas, I stole that from you. Or the hours in which they're open.
Well,
And if we just approve it, we lose control of all those things.
The motion that's on the floor now is a motion to delete all references to age limitations in Mr. Perney's original motion. But I would like to refer you, after the staff report, there's a framework for reaching or evaluating issues and options. There's the Kansas Indoor Clean Air Act, and then after that is the licensing provisions from the city of McPherson. And I would just read those to you or go over them. No minors will be allowed in the businesses, and the businesses would be subject to inspection by city police, fire, and code departments. No person would be allowed to obtain a license if he or she had a controlled substance or drug conviction, deferment, or expunged conviction. A drug conviction would be ground for loss of a smoking lounge license. They would have to have an on-site or off-site smoke detection system. There are hours of operation in there, and there is a licensing fee. What the city of McPherson did was they chose to set up a business license mechanism for doing that. And what staff was trying to explain, that basically the conditional use permit process serves as a substitute because City of Salina does not have, as a rule, business licenses. So if commissioners were concerned to address or have anything similar to what the city of McPherson has in there, those types of things could be addressed through a conditional use permit. Those types of things could not be addressed if they are listed and classified as a permitted land use. And again, reflecting some of the concerns of law enforcement is that there's lots of things that you can vape that aren't legal substances. And so if you had a vape shop and they were not marketing substances that were legal uses, having a conditional use permit and revoking that conditional use permit is a means to shut them down that is a lot cleaner than if they are a permitted land use. So
But they're regulated by the alcohol, tobacco, and firearms, so they're regulated by them too. They can't sell illegal product, or they're going to get shut down anyway, aren't they?
that is correct.
Right.
So why would we need to step in and be regulating this when they're going, if they're just selling illegal product, and we aren't going to be taking control of it
If you
anyway.
decide in your own minds as planning commissioners that there is no commercial location anywhere in the city of Salina that might be considered not a good location for an electronic cigarette establishment, then you should make them permitted uses. If you in your mind can say, well, there might be locations that we wouldn't want electronic cigarette establishments to locate within some of our commercial areas, then they should be conditional uses. But if in your mind there's no such thing as a bad location, then they should be permitted.
We have the same restrictions on liquor stores, don't we? In the same districts that we're talking about?
The only difference is that liquor stores cannot be within 200 feet of a school or church or daycare.
So I have a question about procedure, or just to state an understanding. As I understand it, and this may disagree with what I heard from you, Mr. Andrews, that we've already decided, we're not voting on whether the age question is a part of that. It seems like Mr. Perney and Mr. Bossmeyer already removed that from the motion.
There needs to be a vote to amend the original motion to delete any reference to age limitations. So there still needs to be a vote on that, and then you will get back to Mr. Perney's original motion, which is option 4 in the staff report.
You would need to vote something that only went to a second, to amend it from the second?
Or could I just withdraw the whole motion and just give up at this point?
What, we're talking about principle here, Edna.
I suppose, wouldn't the easier way be able to take roll call and just let the motion fail?
Then if Mr. Perney's amending his motion and the seconder agrees with that, then we're back to the original motion, which is option 4.
And that was my understanding.
Yeah, I thought that's what we had
I thought
done.
that's where we were at. So,
And I'm going to add my comments to Mr. Box's. I agree with him. Maybe I'm just restating it, but I think that there could be, we don't know how these establishments are going to permutate in the future, so I think for them to be conditional makes more sense than to permit them.
I also agree with that. I really do think that we need to at least initially take a pretty good look at what's going on here.
okay. Any other comments?
So the other part of Mr. Perney's motion was that...
It's just number 4. The only option we have is number 4 we're looking at. There is nothing else to it but read number 4, and that is it. We're going to vote on that.
All right, that's fine. I'm good with that.
We're going to vote on that.
I have a motion and second, option number 4. You're going to need to raise your hand. Those in support, please raise your right hand to indicate support.
I'll go ahead and do that.
Okay, deny, raise your right hand. Motion fails. Chair will entertain another motion.
Can we sit here later?
We could just make a motion to table this till we think about it a little bit, couldn't we?
No, let's go ahead and vote.
Enough thinking.
I think Abner and I are restricted from making a motion on this.
Let me try to articulate why. So it seems to me that the remaining concern, Mr. Perney's, is the allowing of hookah lounges under any circumstance. Am I hearing that correctly?
We're not going to allow hookah at all. Nobody wants to do that.
I think that
But that's what but if we vote on this proposition as presented.
Is
we are.
why treat electronic cigarette establishments different than CVS Pharmacy or Walgreens or Dillon's?
And the only reason I changed my thought, because I was on board with it until Commissioner Ryan says it could get, I mean, if 9 of them open up in a row, I'd like to stop the 10th one.
Well, that's not fair.
Everybody's.
Why would you do
I'm
that?
just saying, in one whole particular block. I would hate to see the 100 North block of Santa Fe become e-cigarettes. And I guess I agree with him by shifting that. Is at some point you could probably say that's probably not conducive for the downtown area to happen.
I personally am in favor of number 2 and then treating everything separately, but I don't think that's going to fly. So, Mr. Chairman, I'd make the motion that we take Planning Commission alternative number 1 and see if we can get a consensus on
Why
that.
in that is C1 and C7 taken out?
Because
Just because there's so
C1
few
doesn't
of them?
allow any retail uses, and C7 is designed to serve interstate and highway travelers, and it tries to set aside areas for hotels, motels, and restaurants, things of that nature.
I have a motion on item number 1. Before we do any further discussion, can I get a second?
Second.
I have a motion and a second. Any discussion before vote? Hearing none, please raise your right hand. All in favor of the motion and the second indicate by saying aye with your right hand. Aye.
Let's get it over with.
Decline, your right hand. Not sure what the vote is, but 7-2, does that sound right?
There's not.
All of you that stay on planning commission can deal with this.
Sorry, what's the
Who were
question?
the 2 opposed? Crystal missed that. Ken and...
Kennedy and Purdy.
We agreed for change. Well, we don't know why. We didn't necessarily agree for the same reason.
That recommendation will go forward to the city commission, and then these are all legislative matters, so they will have the final say on any legislation. Your reward for this evening is that you get August 5th off. So we have no items scheduled, so if you want to take a field trip or do anything on the 5th, you'd be free to do that, so.
Great. Thank you again to council, both of you, Mr. Martin, for sticking around, and appreciate it to Mike for all of his comments. This meeting is adjourned.
Cigarettes, but they also apply to cigars, with a big exception. The FDA is considering exempting from the rules what it calls premium cigars, and it defines premium as a handmade cigar that costs at least $10 each. Lee notes that definition leaves out J.C. Newman's machine-made cigars that tobacco stores sell for $1 or $2.
And we're the only company in America still making cigars like this on these antique machines. So unfortunately, we're in danger of being shut down as a result of a definition.
J.C. Newman executives are concerned about regulations that would require thousands of hours of testing and FDA approval for any new products. They also worry the FDA could require them to update their 80-year-old manufacturing process. On J.C. Newman's clock tower, there's a banner. It reads, "Save this factory." Many have responded. Florida's governor has sent a letter to the FDA. So have members of Congress, including Kathy Castor, who represents the Tampa area. All are asking the FDA to extend the premium cigar exemption to include those made at J.C. Newman's factory. Castor says these are tobacco products marketed to adults, not children, sold only at specialty tobacco shops that are smoked occasionally.
We think it's appropriate for FDA to train their sites on the products that really are marketed to kids that are smoked with a frequency that would cause addiction. And at the same time, they can save the jobs in the Tampa Bay area.
In its proposed rule, the FDA cites the well-documented health risks associated with cigar smoking. Many public health groups are lobbying the FDA to oppose any exemption for cigars, no matter how they're made, how much they cost, or whom they're marketed to. Vince Wilmore with the Campaign for Tobacco-Free Kids says this is one of the first major rules the FDA has proposed since Congress gave it authority over tobacco 5 years ago.
Which is why we think it is so critical that FDA not include any exemptions in this rule, that it would set a really terrible precedent, that if they do exempt some tobacco products now, it will only encourage tobacco companies to come back and try and get even more loopholes in the future.
The FDA is accepting comments on the new regulations until next month. It may be a year before any new rules take effect. Greg Allen, NPR News, Miami.
Finally this hour, music from a tenor saxophonist and composer with a few firsts to her name. Last fall, Melissa Aldana became the first female instrumentalist and South American musician to win the Thelonious Monk